list. All matter item 1.
May I please, your lordships, on behalf of Mr. A.K. Nandaman. What has happened, my lord? In this case, the petitioners had challenged the inaction of the opposite parties in not paying any compensation, even though the petitioner's land was submerged in the minor irrigation project, my lord. Thereafter, joint inquiry was conducted, my lord, in 2000. In 2000, as per joint inquiry report, my lord, this honorable court passed order on 12/2/2014, my lord. My lords, may kindly see the order dated 12/2/2014, my lord. On 12/2/2014, my lord, this honorable court directed to pay compensation to the petitioners in view of the joint inquiry report of the year 2000, my lord. Thereafter, by order dated, my lord, 18/4/2017, my lords directed the Lorded Council for the state to file the compliance affidavit, my lord. They did not file the compliance affidavit, and the opposite party number 3 was directed to be personally present if the compliance report will not be filed, my lord. They did not file the compliance report. Subsequently, what happened, my lord? They have conducted another inquiry report, and in that inquiry report, I have been served with a copy, and it is stated that the original petitioner, the petitioner number 1, has expired in the meantime, and none of the legal heirs are willing to get the compensation, my lord.
Then
I have to take instruction in that.
no. We can't keep adjourning the matter, sir. This is a 1996 matter. We are not adjourning.
Then
The compliance report has been filed by the collector on 4th July 2017.
Right. And if anyone has any grievance, let them file a fresh petition. You say the petition concerns non-payment of compensation for land acquired for a minor irrigation project in Gangabahal MIP of Patnagarh block of Balangir district. Pursuant to the orders passed by this court on 12th February 2014 and 18th April 2017, a compliance affidavit has been filed on 10 July 2017. First off, there has been no affidavit in response thereto from the side of the petitioners. Paragraph, the concept of the petitioner states that petition number 1 has in the meanwhile expired. Petition number 1 has expired.
yes, my lord.
And his legal heirs are not coming forward to claim any further relief. Paragraph. In the event any of the legal heirs of petition number 1 have any further grievance, and if permissible in law, it will be open to them to seek appropriate remedies in separate proceedings. The petition is disposed of.
Item number 2.
May I please, Your Honor, may I take your lordships to order dated 16/4/2021, my lord. It has not yet been complied with, my lord. In spite of the direction of this honorable court, the names have not been supplied with to take steps, my lord. They are the daughters of Maharaj Pradeep Chandra. Order number 16 dated 16/4/2021.
1 minute.
Thereafter also it was listed, but till today they have not supplied, my lord.
You tell us what the matter is about, madam.
Matter is with regard to, my lord, unless they are substituted, it cannot be heard. And the matter is that Maharaj Pradeep Chandra Bhandya, my lord, of Mayurbhanj district, Mayurbhanj estate, my lord, at that time, it was the son of Maharaj filed a suit for eviction and for khas possession of the property that is part of the deity. And at the time of merger, some properties were given to the Maharaj and some were kept with the government and some were private properties. And admittedly, in this case, admittedly, the power of attorney holder has filed the suit. The power of attorney, as the power of attorney holder of Maharaj, he has filed the suit, my lord, and he has not been examined. So it is a very.
That is not enough. You'll have to tell us more about the matter.
Yes, ma'am.
This is an appeal, correct?
Yes, ma'am.
Ah,
That
so
is
tell us what.
appeal
Tell us
against
take us to the single judge's order.
Yes.
Yes. Are you appearing in this matter, sir?
Are you appearing?
He
in
is
the matter?
one of the legal heirs.
He is one of appearing to one of the legal heirs.
But let him speak. Let him come to that other mic and speak.
Please come to the other mic.
No,
On
he
your
is
left.
not appearing on behalf of the other side.
Oh,
He is with me.
All right. You're a designated senior counsel, sir.
Not,
No. Your colleague. He's a designated senior counsel. I see.
Because of that.
Tell us, madam.
Take it to the. Some legal points are also involved. Single judge judgment. Shall I read it?
Mr. Mahanti,
Yes, ma'am.
I hope you're seeing what is happening. Not.
Oh, this ground. No.
Just the single judge's order now.
See, he is suffering from paralysis, so that his hands are not.
No difficulty. Just tell us what
Do it
season.
properly.
All right. What does the single judge say?
Tell my lord, because of this, it has been listed. I have not gone through the orders properly, my lord. It may be taken up, my lord, tomorrow, day after tomorrow. Because
We're not
I am
prepared
ready.
to. No, we're not prepared
Several
to adjourn.
times I have argued the matter, my lord, various occasions. Because I want the matter to be also heard, my lord.
Yes.
Because all the order sheets and everything that is with me, and as because the order has not been complied with, I thought that only on that.
No, there's no thinking. In this bench, let me make it very clear. Do not presume things here. We are very serious about all matters, madam.
After that, it was listed before your honor, and your honor was pleased to pass the order that it may be placed before the assignments. Then thereafter also order has been passed.
What we can do is, madam, what we can do is we can pass it over for you to get ready with the matter. All right, we are not adjourning it. We are making it very clear to you.
Yes.
We are not adjourning this case.
Yes.
All right, pass over.
serial number 3.
Counsel, the petitioner seeks leave to withdraw this petition. Dismisses withdrawn.
Serial number 4.
Wait, please, Your Honor. This is Balarpur in the NCLT. I will not trouble your lordship. I
All
filed
right.
the NCLT's order.
The petitioner is already before the NCLT, therefore this matter cannot proceed. It is disposed of.
About the statements.
Lordship, I said disposed of so that the workmen.
Yeah, I said disposed of. Right.
Obliged.
I am for the statements.
Yes.
Right. Okay.
Number 5. Special weekly list item number 5.
None appears dismissed from knowledge.
Special weekly list item number 6.
May I preach your lordship? My lord, this is a matter relating to the Industrial Dispute Act, challenging the award of the Industrial Tribunal Rautla, my lord. And I am on behalf of the electricity company, OSCO, now as redesignated as under the Transport Act. It is known as TPWODL, Tata Power Western Orissa Distribution Limited.
All right. On the oral prayer of the petitioner,
My lord,
the name of the petitioner is substituted as Tata Power Western Orissa Distribution Limited. Yes. Now proceed with the matters.
my lord, first of all, I may place, my lord, the schedule of reference, page 2 of the my writ application. I will.
Yes.
Page 2, I have reflected what is the schedule of reference, what is the answer.
Right.
The schedule of reference, my lord, whether the action of the management in reducing cost of helpers as against the terms as stipulated in Orissa electricity reform within bracket transfer assets, mobilities, proceeding and personal of Gridco to the distribution company, Rule 1998, as against this spectacular increase of consumer of legal and justified If not, what should be the principle? Now, this is the issue, this is the reference before the London Industrial Tribunal, and the answer is page 70, my lord. Last annexure, award, and then page 70, my lord, internal page 7 of the award. And then the last 10 lines I am reading. My lord, page 70, my lord.
Yes.
As has been discussed in the foregoing paragraph of the OSCO Limited responsible in filling of the post of helper to meet extra burden to the workers covering its area, the second party doesn't have the right to ask the first party management to fill up the vacancy of the helper post. In view of the materials available on records and opined to the executive engineer as MW 2 and 3, the recruitment filling of the vacant post helper is absolutely necessary in the present work is being managed with to reduce staff of helpers. With due respect, I am the humble view that the principle and other rulings cited either side have no application in the scope and ambit of the present case.
How does this order prejudice you, sir?
That is the finding of the London Industrial Tribunal.
No. How does this award, this is what you have challenged, correct?
Yes, my lord.
How does it prejudice you?
How, my lord? Now what happens, my lord, para 9, next page, 9. Issue number 3, the second party union is entitled to relieve shortfall subject to following observation of OSCO Limited is directed to fill up 50% of vacancy post helper through the proper advertisement and test.
So how does this
affect, my lord? This order of the Industrial Tribunal violating section 10(4) of the Industrial Dispute Act, because that is out of reference. To whom we fill up or not, that is only give to answer the reference. He cannot direct.
What is the term of reference? What is the term of
The
reference?
term of reference I have imposed, my lord, page 2 of my writ application.
Yes.
Whether the action of the management in reducing the post of helper as against the terms stipulated in Orissa Electricity Reform Act and proceeding and personal grid code distribution of the company like Rule 1998.
So
Against this
this has been answered in your favor. This has been answered in your favor.
No, my lord. Now the direction is.
No, 1
reducing
minute, sir. I'm just asking you. So this reference has actually been answered in your favor, correct?
Yes, my lord. The answer
In
is,
the
my
passing, he has said that you fill up 50% of the vacancies by issuing advertisement. How does that help? How does that prejudice you?
lord. That order of the industrial is out of jurisdiction so far.
How does it prejudice you, sir? Somebody is asking you to fill up 50% of your post through advertisement. How does it prejudice you?
My lord, so far as section 10(4) of the IDA is concerned, he has no power. And deciding that is settled law
Sir, why don't you answer the
by the
question?
full bench of the Honorable Supreme Court.
You're not in the habit of answering questions,
My lord,
correct?
my lord.
No, how it is going to affect you? Because the reference has been answered and it is in your favor. And there is only an observation to the effect that to fill up 50% of the post.
No, that is a direction, my lord. That is direction.
Yes.
That is violating separate.
What will happen to your great enterprise if you fill up 50% of your posts, vacant posts for advertisement?
Well, that is
You
my-
will come to a grinding halt.
That my lord.
Your establishment will come to a grinding halt.
My lord predecessor granted stay operation of the order. And counter has not been.
What is your answer? I don't understand. Are these arguments?
My
Why don't you answer the question, sir? How does this prejudice you?
My lord, my answer, my lord, it is the executive statute, my lord, for that is in 10(4) of the idea. That order is, that is the without jurisdiction of the industrial.
All
Tribunal. And my lord, one placing and judgment of the appeal court, my lord, find it, that is my lord dispose of the matter. That is my lord. The 3-bench judgment, my lord.
Yes, sir.
That is the measure, the constitutional of India, the scope of power of the Honorable High Court in the interference with the decision of the tribunal when justified. A writ of category is generally granted when a court has been acted without its excess of jurisdiction.
This is
It
about
is the available of the case where the tribunal through competent to enter upon to the inquiry and act flagrant
All right.
disregards.
All right.
Para 11 of the said judgment, my account pays. Para 11 of the said.
All right, sir. All right. Anything else, sir?
Nothing else.
All right. The challenge in the present petition is to an award dated 27 September 2003, passed by the Industrial Tribunal Rourkela, Industrial Dispute Case number 9 of 2002. The dispute referred to the tribunal for adjudication was as under. Take from page 64. Apart from one issue regarding maintainability, the main issue framed by the tribunal for adjudication was on the same lines as the above term of reference. The above term of reference was in fact answered in the affirmative by the tribunal, that is in favor of the management and against the workmen. Paragraph
11, madam.
The tribunal, however, in the passing towards the end of the award, issued a direction to the management to fill up 50% of the vacant posts of helpers, open quotation, through proper advertisement or test or interview and selection, unquote. It is this portion of the impugned award that has triggered the present petition, in which, while issuing notice on 4th February 2004, this court granted a stay to a limited extent, stating that any recruitment made by the management, either directly or indirectly, to the posts of helpers, semi-skilled, unskilled, shall be subject to the result of the writ application, unquote. Paragraph counts for the petitioner relies on the decision in Parry and Company Limited versus PC Pal, AR 1970 SC 1334, to urge that the above direction issued by the tribunal was beyond the scope of its jurisdiction, as it was outside the scope of the reference paragraph. As the court views it, the direction issued is totally innocuous. All that it asks is that if there are vacancies in the posts of helpers, the management should fill up at least 50% through a regular advertisement and regular procedure. Stop. The court is unable to appreciate how the above direction would cause any serious prejudice to the management. Stop. Despite repeatedly asking counsel to explain in what manner the petitioner is actually prejudiced by the direction, learned counsel for the petitioner was unable to do so. Consequently, the court sees no reason to interfere with the impugned award. The petition is dismissed.
Special weekly list item number 7.
No instruction, man.
Counsel, the petitioner states he has no instructions. Why there are two petitions, sir?
In that case, there is a cross appeal, no, sir.
I see. Cross appeal for what?
By Hirakud, that.
Okay, 12133, none appears, dismiss the non-prosecution. All right. 5096, counsel, the petitioner states he has no instructions. It's dismissed.
My lord, this we preferred intervention petition in terms of IA 4018 of 2019.
Appearance of never noted in item 7.
Intervention doesn't survive, sir. The petition itself is going. The intervention application doesn't survive since the petition has been dismissed. Yes.
Special weekly list item number 8.
May it please, my lord. My lord, I am also, my lord, I am investing.
Yes.
My lord, the petitioner is a voluntary organization, my lord.
All right.
Engaged for imparting education to the mentally retarded children and upliftment of the children, my lord.
Yes.
Lord, a parent counselor post fell vacant for a particular period, that is from 22/8/1988 to 34/89, against which the opposite party number 1 in whose favor the award has been passed and is being assessed was appointed, my lord, for a period of my lord, 8 months, my lord. Then, my lord, the period came to an end, and instead of terminating her, another leave vacancy post was available of the special educator, for which the petitioner, opposite party, didn't have the qualification, but was adjusted against it for a period of 1 year. During 1 year, she wanted to go for a training of, to obtain the diploma, and his case was recommended. But after 1 year, my lord, the incumbent joined, and the petitioner service came to an end on 29/5/1990, my lord. He also applied for extension, that was not granted, my lord. Then on 24/9/2090, according to the instruction of the state government, open advertisement was made, my lord. As the petitioner didn't have the requisite qualification, then he applied for a lecturer in teacher in psychology, my lord, and he was not selected, my lord. He was placed at third, my lord. Then, my lord, he filed this. He raised an industrial dispute, and this was a referred, my lord. Now the tribunal has held that because he continued for a period of 1 year, 8 months, my lord, continuous period of service, 1 year, 8 months.
Mr. Manti,
My lord.
the relief granted to her is reinstatement with 25% back wages, correct?
Yes, my lord.
Was there a stay of that award by this court, sir?
No, I don't remember, my lord.
I do not think so, sir, because I have been going through the order sheets.
But he never came back to be reinstated, my lord.
So then you're all in a happy position, sir, because the award is more than 18 years old.
And
if she has not come forward to enforce it, I don't think there should be any problem at all for you.
No, but the question is, my lord.
We leave all the questions open, sir.
My lord,
I am for the opposite party number
my lord, I have collected from her.
What have you done?
I am for the opposite party number 1. As per the instruction, because your word matter, they are just there, but I have to go through because
I'll just show you the paper.
Because my law and senior constable are arguing this.
No. Just go through it, sir.
As per she was not allowed to join, that was my instruction. Now she is 58 years old lady.
But from her Facebook account, we could download. Lord, it seems that he was a former principal of English medium school from 1995 to 2005. Then modern public school from 2005 to 2007.
So she's otherwise been gainfully employed.
Then lecturer at Padmavanti College from 2007 to 2008. Then Macaulay International School from 2014 to 2016, my lord.
Very good, sir. Very good. I think everybody is reconciled and very happy. So we'll leave all questions open now. So there is no stay, sir.
Sir, 58 years. Yes,
I know. So anyway, she is not coming forward. She has presumed, her lawyers have presumed there is a stay, so they have not advised her properly. So she has not even sought enforcement.
You may observe it.
This happens in so many labor matters, sir. It's very unfortunate. Despite no stay granted, the workman, because the lawyers have presumed there is a stay, they have not done anything.
No, Lord, because of the reason that he was gainfully employed and he was getting
No,
maybe we don't know.
Not been gainfully employed.
Anyway, there's no point. There's no stay. You've done nothing, sir, for 18 years.
May I pray for a Passover so that I can take instruction?
What will you take instructions about?
Yes.
What will you take instruction about? She's 58 years old.
That's true.
Huh.
So may I
You
submit
say
only
the
one
challenge
thing,
in the
my
present
lord?
petition.
May I submit one thing, my lord?
Yes.
I'm supplying my judgment, my lord.
Everything is judgment, sir. Facts.
Only,
we have to just ignore facts. Only judgment we have to decide everything.
Now, in that case, your lordship can have it.
Why did you answer, first of all, before looking at the judgment? Just wait on. Before looking to that, why did you not seek enforcement of this award?
No, to that effect, actually.
Nothing. But we have to see all judgments. You do not have to do anything.
This case was filed before my join.
But judgment you are ready with. Facts you're not ready with.
Regarding judgment, regarding
Yes.
in that case, the honorable appeals court holder, since the termination, so some monetary benefit can be covered. So this is my, so whether stay has been granted or not, I don't have any interest.
You don't have instruction.
I-
He
I-
just
I-
showed you
I-
the paper
I-
book.
I have
After
gone
seeing the paper book, you're still saying no instruction.
I have just gone through my list.
What did you find a stay order?
No, my.
Answer to the petitioner. You say the challenge of the present petition is to an award dated 30th April 2004, passed by the Labour Court Bhubaneswar in industrial dispute case number 20 of 1993. The dispute referred to the Labour Court for adjudication read as under, reproduced from page 41. The above reference was answered in favor of the opposite party number 1, and a direction was issued to the present petitioner to reinstate her with back wages of 25%. Full stop. When the petition was listed here for hearing on 20th July 2004, it was admitted and the lower court record was called for. However, there was no stay granted of the impugned award. Till date, that position has not changed. Full stop. Unfortunately, however, it appears that opposite party number 1 never instituted proceedings for enforcement of the award, despite there being no stay granted by this court. In all these years, in all the 18 years of pendency of the present petition, no attempt has been made by opposite party number 1 to either seek enforcement of the award or early hearing of the present petition. Paragraph. Mr. Ashok Mohanty, learned senior counsel, appearing to petitioner, states that as per the information available with the petitioner, opposite party number 1 has been gainfully employed throughout this period, and perhaps that is the reason why she did not come forward to get the award enforced. Counsel to the opposite party number 1, however, states that he has no instructions. Paragraph. In the above circumstances, the court sees no reason why it should continue to entertain the present petition. Leaving the questions of law open, the petition is disposed of.
Special weekly list item number 9.
My lord, item 9, the writ petition has become infructuous.
Counsel, the petitioner states that the petition has been rendered infructuous. Is disposed of as such. All right, sir.
Special weekly list item number 10.
The cover matter. I am giving the order passed by my Lord Chief Justice and my Lord Justice R.K. Patnaik. The same matter, my lords, where the tribunal set aside and the earlier order of the same issue has not been challenged by the department. And the lordship will kindly see by virtue of this order, same assessing. Assessment here, my lords, I have marked at page 45 of my brief. ITA number 219, that interest paid to the subsidiary. The earlier judgment of the tribunal was in my favor, page 28. Page 28, paragraph 7, my lords, where the learned tribunal has allowed, we direct the AO to allow the same. Now, this order of the tribunal was not challenged by the department. Now, the tribunal ignoring the earlier order for the assessment year 91-92, page 45, that is ITA 219, CTK 94. Now, they have the learned tribunal restored it to the file of the AO. So that have been challenged by this.
But your rule 28, your lordship, in the order which was cited by the petitioner, my lord, rule 28, my lord, says that there is a 28 say it may be the AO or it to be assessing authority. So the question which has been
AO is the assessing authority.
Yes, to rule 28, kindly have a glance. Rule 28 says to the appellate authority from whom the order of appeal has been preferred or to the ITO where such direction or tribunal may deem fit. So therefore, the tribunal has directed AO to adjudicate the matter.
Why should he adjudicate when the earlier direction is already issued?
No, I'm not saying. Lord, I am saying the Rule 28, which has my senior has been cited, that this cover, the Rule 28 is confined to what I understand that to be appellate authority, because the order of the appellate is challenged before the tribunal. But here the Rule 28 says to the appellate or to the IO as deemed fit and proper.
Anyway.
Therefore, my submission is this question which has answered is not directly covered in this present case. The fact may be some different,
You say, while admitting this is an appeal by the SSC against an order dated 3rd September 2003, passed by the Income Tax Appellate Tribunal, Cuttack Bench, Cuttack.
In ITA
number 219/CTK/94, the assessment year bracket AY 91-92. While admitting this appeal on 10th January 2005, the following question was framed at this court for consideration. Paragraph. It is seen that an earlier order of the tribunal dated 25th February 1994 for the earlier AYs, that is from 1984-85 to 1990-91, already contained a direction, which is at page
28, para 7.
Right.
Looking to the objects of the assessing company.
Correct. Already contained a direction to the assessing officer, AO, to allow the claim of interest.
We are of the opinion that the claim of the
as business expenditure of the SSC company. Consequently, there was no occasion for the tribunal by the impugned order, while partly allowing the appeal of the revenue to ask the AO to again examine the matter. Full stop. Paragraph. In similar circumstances, this court has, by its order dated 2nd February 2022 in ITA 12 of 2004 for the AY 1987-88 involving the same SSC, answered the question in favor of the SSC. Paragraph. For all of the aforementioned reasons, the question framed is answered in the negative, that is in favor of the SSC and against the revenue. The appeal is allowed, no orders is to pass.
Okay.
Special weekly list item number 11.
Item 11, my lord. The senior counsel, Mr. B.K. Naik, has expired in this COVID period, my lord. And D.K. Mahat, I am on behalf. He is the panel lawyer for OFDC, my lord. There is maritime. May I pray or some other day, my lord?
No. We'll pass it over, sir. You get ready with the matter and argue. All right. They're passing it over, you get ready with the matter.
File is not assigned. It is difficult.
Then it's okay, sir. Then whenever file is assigned, you revive the matter. Concept for the petitioner states that although he's appearing in the matter, the file has still not been assigned to him. The petition is dismissed for non-prosecution with liberty to the petitioner to revive the petition as and when the file is assigned and available with him. All right. Assigned to and available with him. All right.
Special weekly list item number 12.
May please. I have filed a short notes of argument here. The limited question of law is whether in terms of the judgments and the settled position of law, the burden of proof regarding 240 days continuous service in a year lies on the workman or the management.
Yes.
So let's say the opposite party has been engaged as a casual, unskilled daily worker and never engaged technical helper, because in the terms of reference it has been mentioned as a technical helper. Subject to availability of jobs.
So take us through the impugned award and tell us where it is wrong.
Well, let's just glance to page number 21 at the finding of the learned tribunal.
1 minute. Tell us the term of reference. Just read the terms of reference.
Terms of reference, Your Honor, as page number 11, Annexure 1.
Kindly read it, sir.
So whether the action of the management of the Tata Iron and Steel Company Limited, Paradeep, in terminating the services of Sri Sankarshan Sahu, technical helper, with effect from 4/8/90 is legal and justified. If not, what relief Sri Sahu is entitled to?
Since when was he working for you?
He was working for, let's say,
From 7/5/1985.
85 to 90. 85 to 90
For almost 5 years.
Mila.
Right.
In each month, 8 to 10 days. You are.
That we do not know, sir. That you can refer to the award, what evidence that you led.
No evidence was actually, no documentary evidence has been adduced to us. Let's say glance to page
Just
number
come to page 15, sir. On the other hand, page 15, first line.
Running page 15.
First line, running page 15.
Marked as exhibit number 1 and 4.
Yes. Sir, come to page 15. Are you at page 15, sir?
Running page 15.
In that, you will find in the first line, on the other hand. The sentence starts on the other hand. Page 15, sir. 15 on top, first line. First line, what are you finding?
Marked as exhibit number 1.
After that full stop, what are you finding?
On the other hand,
read that.
The management has examined 2 witnesses, namely MD Kamaluddin and Ajit Kumar Hota, as MW number 1 and 2 respectively, and has relied upon the xerox copies of the documents as well as advertisement for the post of helper and other posts, application of the workman letter dated 26th of February 90 of assistant divisional manager Paradeep, list of candidates for the post of helper, letter dated 24th of March 1990 of assistant divisional manager, list of recruitment of helpers, rating chart, appointment letter and other documents relating to the registrations, filing of returns, treasury challenge, list of employees, application for renewal of registration and renewal of registration, marked as exhibit A to H by 19. Also in that post,
come to page 17, sir. There's an underlined portion, nothing material.
Has been elicited by the management to disapprove his evidence. In that sense,
disprove. Just read on, sir. Continuously, if you read, you will get a better understanding.
Nothing material has been elicited by the management to disapprove his.
No, disprove, sir. Not disapprove.
Disprove his evidence with regard to the continuous service of the workmen having been tendered by him in the establishment of the management. On the other hand, the evidence led by the management through MW number 1, MD Kamaluddin, reveals that he joined in the establishment of the management with effect from November 89, and since the date of his joining, the workman has known to him, who was then doing the work of the cleaner under the management. He states that in his evidence that the workman was working in the shift duty starting from 6 a.m. to 2 p.m. and still he is continuing in his employment. He has denied his knowledge if the workman was engaged as and when required by the management. During cross-examination, he has clearly stated that by the time he joined in the service, the workman was working as helper under the management. The work is done in 3 shifts in the post. The work of electrician is done in the first shift, but the mechanical work is done in 3 shifts. In most of the times, the workman was engaged with mechanical work. He admits that the workman was receiving his wages in voucher.
So the entire case is based on appreciation of evidence, sir. What is perverse about the impugned award?
In the underlying portion, as nothing material has been elicited by the management.
Correct.
As per the settled position of law, your lordship, it is the responsibility of the workman.
Yes. That is why he is examining not only himself, he is examining 2 others also.
Well, in the meantime, the award has been stayed subject to compliance of 17B. We have complied that.
All right.
And they attain the age of superannuation.
All right. So now we should set aside the award. Correct? Without any argument.
No, it has attained the age of superannuation.
This is the strategy. Keep the writ petition pending till the man superannuates and then tell the court, sir, he has now superannuated, set aside the award.
With due respect to lawship, previously.
No need to have any argument on fact. Just produce one Supreme Court judgment and say set aside the award. So this is an appreciation of evidence. You have to show what is perverse about the impugned award.
My submission is that shifting of onus
No,
It's
no.
not correct, Your Honor.
He discharged his honor, sir. There was no shifting. He examined 3 witnesses. You examined 2 witnesses.
My lord.
His witnesses were cross-examined by you. This is not a case where evidence was not led by the workman.
Documents has to be produced, like the
Those documents are with you that have been appreciated by the labor court. They have come to a conclusion on that basis. You are in a 226, sir.
My lord.
It is not a first appeal.
No, my lord. I know the scope of writ of such.
You said the challenge in the present petition is to an award dated 30th July 2005, passed by the Labor Court Bhubaneswar in industrial dispute case number 120 of 1994. The dispute referred to the Labor Court for Adjudication was as under, reproduced from para 2, page 11. The case of the workman was that he was engaged as technical helper under the management with effect from 7th May 1985 under the direct control of the divisional manager at Paradip Port Branch on a daily wage basis at the rate of rupees 25 per day and rendered continuous uninterrupted service from then on till 4th August 1990. Full stop. Questioned his illegal termination with effect from 4/8/1990 as being in violation of Section 25 capital F of the Industrial Disputes Act 1947 bracket ID Act. Correct. In order to substantiate his claim, the workman examined himself as WW1 and 2 other witnesses and relied on Xerox copies of documents, including temporary pass for civil workers, call letters, and so on. On the side of the management, 2 witnesses were examined. Paragraph. The Labor Court has in the impugned award thoroughly discussed the evidence. It has come to the conclusion that nothing could be elicited on the cross-examination of the workman's witnesses to disprove their evidence regarding the workman having rendered continuous service. Full stop. The evidence rendered by the management witnesses was also discussed in great detail, and it was concluded that the workman had been able to establish his case of having rendered continuous service of 240 days in the last preceding 12 months prior to his termination. Full stop. The inevitable conclusion, therefore, was of non-compliance with Section 25 capital F of the ID Act. The operative portion of the impugned award was granting the relief of reinstatement in service with lump sum compensation of rupees 3,000 towards back wages. Paragraph. While directing notice to issue in the present petition on 2nd January 2006, this court stated the operation of the impugned award subject to compliance with Section 17 capital B of the Act. According to constitutional petitioner, the above interim order was complied with, and now opposite party number 1 has already attained the age of superannuation, making it impractical for the management to reinstate him in service. Paragraph. Reliance is placed on a judgment in range of Forest Officer versus ST Hadimani, AIR 2002 SC 1147, to urge that the burden of showing that he had worked for more than 240 days continuously the preceding 12 months was on the workman, and that in the present case, the workman had not discharged that burden. Reliance is also placed on the decision in Krishna Bhagya Jal Nigam Limited versus Mohammad Rafi, 2009-11 SEC 522, which is to the same effect. Paragraph. While the ratio of the aforementioned two decisions is unexceptionable, as far as the present case is concerned, the court is satisfied that the workman discharged the burden placed on him by not only examining himself but two other witnesses, and also placing on record the relevant documents and proving them. Stop. These witnesses were subjected to cross-examination, but nothing could be elicited to contradict their version that the workman had indeed rendered 240 continuous days of service in the preceding 12 months prior to his termination. This being a matter purely of appreciation of evidence, and with the counsel of the petitioner being unable to point out anything perverse in the impugned award, the court is not inclined to interfere. Paragraph. Therefore, notwithstanding that one portion of the award regarding reinstatement cannot be practically implemented at this stage, the court sees no reason to interfere. The petition is dismissed.
Your Lordship, I'm appearing on behalf of the workmen opposite party.
All right.
Special weekly list item number 13.
Item number 13, no instruction. Counsel petitioner states that he has no instructions. Dismiss for now.
Special weekly list item number 14.
Item 14 instructions.
Counsel petitioner states been rendered instructions.
Special weekly list item number 15.
Item number 15, no instruction.
No instructions.
Special weekly list item number 16.
You may please, Your Lordship. I'm giving a death chart.
Yes.
The present petitioner was a government servant. He was sent on the deputation on terms of foreign service, terms and conditions of foreign service to the State Handloom Weavers Cooperative Society. This State Handloom Weavers Cooperative Society is neither a state nor it is a government undertaking, my lord. It is completely registered under the Cooperative Society Act, Orissa Cooperative Society Act, my lord. While working in the said State Handloom Weavers Society, he was repatriated on 1/8/1989. My lord, the period is from 24/4/1984 to 1/8/1989. This period he worked in the State Handloom Weaver Cooperative Society Limited. While working, after his repatriate to the parent department, audit report shows some shortage of amount, 7 lakh some odd, my lord. The Weaver Cooperative Society, Handloom Weavers Cooperative Society Limited, filed a dispute under section 68 of the Orissa Cooperative Society Act. That was referred to the arbitrator, and arbitrator passed an award on annexure, my lord, that is annexure 1 on 1/11/2013.
2003, sir.
2003, my lord. Holding that the petition is liable for that 7,92,046 rupees 8 paise plus interest at the rate of 12%, that comes to 14 lakh some odd. The petition did not prefer any appeal against that award. That became final, my lord. Now it is the question of the recovery, my lord. That the State Weavers Cooperative Society Limited did not file any petition for execution of that award under section 103 of the Orissa Cooperative Society Act. They wrote a letter to my employer
the state government, my lord, to recover it from my salary. And under Annex 3, my lord, the director of the Textile Handloom Orissa, under whom I was serving, directed to deduct 2,500 from my salary, my lord. Your lordship, I will come to page 19, my lord.
Yes.
Annex 3. In pursuant to the judgment passed by the arbitrator, director of the Textile Orissa dated 1/11/2003, in dispute case number 2 of 1997 of the Orissa State Handloom Weaver Cooperative Society Limited, a letter memo number 1 of Orissa State Handloom Weaver Cooperative Society Limited, Bhubaneswar, a sum of rupees 14,16,442 rupees 40 paise. This is 7,92,046 rupees 8 paise towards principal and 6,24,396 32 paise towards the interest at the rate of 12% is recoverable from Sri Ramesh Chandra Pani, weaving supervisor, towards decretal amount. Sri Pani has failed to deposit the above amount with Orissa State Handloom Weaver Cooperative Society Limited, Bhubaneswar, despite direction issued. In view of the lapse on the part of the Sri Pani weaving supervisor, it is hereby ordered that the above amount shall be recovered from the salary of Sri Pani as per the rule 182 and 183 of Orissa Treasury Code, commencing from the month of August 4 till his retirement, and balance amount will be recovered from his pension and benefits like pension, DRCSG, OBP, and unutilized leave salary. I challenge this order before the Orissa Administrative Tribunal that state government cannot recover this amount under Rule 182 and 183 of Orissa Treasury Code, my lord. The Learned Tribunal by order 17/4/2006 held that it is only a technical aspect, and therefore the original application is dismissed on that ground only, my lord. Well, it is not a technical aspect. Your lords can come to section 103 of the Orissa Cooperative Society Act first.
So you got a stay from this court.
A stay is there, my lord.
So till date, 14
No
lakhs,
recovery.
nothing, not even one paisa of 14 lakhs has been paid back.
Not a single pie has been recovered from my salary.
So you're very happy, sir. You're in a very happy position.
Yes, my lord.
So you are
That
now
is,
63
my
years
lord,
old.
They did not follow the procedure for recovery, my lord. That is not
So
my
now you
fault.
are 63 years old.
My lord, this is not my fault. The petition fault is on the part of the State Handloom Weaver Cooperative Society.
Everybody else's fault, sir. Nothing can be your fault. It has to be everybody else's.
My lord, your lordship can come to section 103, my lord.
No. Tell us about the equity
That
of
is
the
the
situation.
provision
You are
of
on a
law.
226, sir.
Yes. My lord,
You are in a 226. You'll have to tell us the equity of the situation.
226 and 227,
You
my
did
lord.
not challenge an award of 2000.
I did not challenge, my lord, but it cannot be recovered under.
1 minute, sir.
Because
So
I am
18 years, without challenging an award which requires you to pay 15 lakhs of rupees,
Yes, my lord.
you managed not to pay a single paisa.
Well, let them file the execution case, my lord. The execution proceeding is there under
What
the
is your
act
work
itself.
today, sir? You're 63 years old. You're a retared government
I am a
servant.
retired government. My lord, your
What are your
my lord,
properties?
statute provides that the procedure for
No, let us see.
executing this award.
Instead of
They did
sending
not-
instead of sending everybody in a wild goose
My
chase,
lord,
let us
suppose, my
cut
lord,
to the reality of the situation.
Suppose a money suit is filed a private person in a civil court. A decree was passed in the civil court that the person is liable to pay the 50 lakhs rupees.
Correct. So you are coming to this
If
court, right?
that person is a government servant, can that private person come to the government and say that it is maybe recovered under rule 182 and 183 of the Treasury Code, my lord?
All right. So while
it is just to your Cooperative Society, Handloom Society, just like a private person, my lord. Here, the society has not filed the execution case under section 103 of the Orissa Cooperative Society Act for recovery of that amount, my lord. You also can come to that provision, my lord. Well, every order made under section 67.
Mr. Mohanty, if you're not attentive to what is happening this side, and you only want to read whatever you want to read, argue
Well, my
only
lord,
whatever you want to argue, there's no problem. That is also advocacy. That is also advocacy. Just don't pay attention to what the
No,
bench
I
is
am paying
doing, what the
attention,
bench is
my Lord,
asking.
you have not-
Somehow just argue your case, show Supreme Court judgment, read provision, and somehow finish your argument.
No. I don't want. I don't want to do
No.
that.
Sometimes we get that impression that lawyers are not even pausing to say, I have made a statement. What is the judge saying? How is he reacting?
Yes, my
So that is also advocacy, sir.
Yes, that is a
But
part of the
now that stage has passed, now you read whatever you have to.
No, what your lordship may put question, I will give the answer, my lord. Your
No,
lordship.
after all this,
I am ready to give the answer.
you argue whatever you have to argue. Yes.
My lord, section 103, my lord. Every order made under section 67, subsection 1, section 102 of section 1 of section 108.
Right.
Every decision or award made under section 70. And every order made under section 75, 109, 111, 112, 113, and 114 shall, if not carried out, on a certificate signed by the registrar or any person authorized by him in that behalf, be deemed to be a decree of a civil court, and shall be executed in the same manner a decree of such court. Then clause B, be executed according to the law and under the rules for the time being in force for the recovery of areas of the land revenue, provided that application for recovery in such manner of any sum shall be made to the collector within 12 years from the date of fixed the order, decision, or award, and if no such date is fixed from the date of the order, decisions, or award, as the case may be, and shall be accompanied by the certificate signed by the registrar or any person authorized by him on that behalf. See, my lord, be executed by the registrar or in person empowered by him in that behalf by the attachment and sale or sale without attachment of any property or the person or a society against whom the order, decision, award has been obtained or passed, my lord. This is the position of law, my lord. Then I am taking to a lawsuit that is what is the Orissa Treasury Court said, Rule 182 or 183.
Set out at page 21.
21. My lord, 182 says attachment of pay and allowance, etc. for debt. When pay of a government servant for debt, my lord, for a government servant is attached by any order of a court of law, it is the duty of the officer receiving the attachment order to see that the proper deduction is made satisfaction of such order from the pay bill of the government servant concerned. This is not the provision to recover the awarded amount, my lord, and execution proceeding is there. I, my lord, cite two decisions of this on one decision of this honor court and another decision of honor Supreme Court. Well, 2009, 2009, 2 OLR. Only one paragraph I am citing. It is the settled law that when the action of a state or its instrumental is not as per the rules or regulations and supported by the statute, the court must exercise its jurisdiction to declare such an act to be illegal and invalid. Then, my lord, this is paragraph 46, then 52, 53, my lord. The Supreme Court has taken the same view in Ramchandra and others Union of India and held that the exercise of power should not be made against the spirit of provisions of statute, otherwise it would be tend towards the arbitrariness. Then, my lord, another decision I am citing that is, my lord, 2005, volume 13 SEC, page 477. This is paragraph.
Can you read the last sentence of this
Yes.
judgment?
That decision, my lord, yes.
I'm talking of Swastik Agency,
Yes,
2009
Swastik
to OLR.
Yes, yes,
This is Sarfacy Act matter, correct?
yes.
It's a Sarfacy Act matter, sir.
Yes, yes, my lord. That's Surface Act.
So come to para 71.
7 to 1.
What was the main reason why the court interfered?
My lord, it is evident that the property has been assessed at rupees 4 lakhs, rupees 4.15 lakhs, and reserve price was fixed at rupees 3.95 lakhs, but it has fetched the value to the tune of rupees 13 lakhs 95 lakhs. The difference between the value assessed and the value received is more than the 3 times. Therefore, even by stretch of imagination, it cannot be held that the valuation has been made correctly. As a consequence, reserve price had been fixed at the lower side.
So you know now why the court interfered, correct?
Yes.
Now come to the last paragraph, para 76.
76, my yes. In view of the above, writ petition succeeds and is allowed.
Come to the last sentence. We further direct.
Last sentence, my lord. We further direct that as the opposite party bank proceeded illegally, it is not entitled to claim for legal expenses or recovery expenses from the petitioner or receipt on the recomputed demand from the bank. The petitioner shall deposit the same within 4 weeks from the date of receipt, failing which the bank shall be at liberty.
So even in that case, sir, although the petitioner succeeded, the petitioner was asked to deposit the entire amount within 4 weeks, correct?
Yes.
So what are you prepared to deposit, sir? 15 lakhs was due in 2003.
Yes.
What are you prepared to deposit? We are in 2022.
They have not filed.
We are in 2022, sir.
My lord, 2022, they have not filed the execution case, my lord.
We are asking you a question. You have come to this court.
My lord,
seeking
if
relief.
they have not, my lord, if they have not filed the execution case, I am not liable to deposit.
We'll take note of that submission. All right. Anything else, sir?
Only another decision, my lord, I am citing that on that principle. The 2005-13 ACC 477. Well, that is it is settled by the law that where statute require a particular act to be done in a particular manner, the act has to be done in that manner alone. Every word of the statute has to be given its due meaning. In your view, the impugn notification fails to meet the statutory mandate. There, here statute provides that execution case would be filed by the petitioner who before the arbitrator, and they have not filed the execution case. Therefore, till the execution case is filed and that the certificate is signed by registrar, I am not liable to pay a single fine.
All right. Yes,
my lord. Here, my lord, when the arbitrator passed the award, my lord, the petitioner was present. He participated in the proceeding, and subsequently the 14 lakh 60,442 was awarded against the petitioner, my lord. Now that order still is in force. That has not been assailed by the petitioner till date. Now, in 12th August 2004, the award was passed. When the department communicated the order that this was the order passed against you, and we are going to attach your property, or we are going to exercise Rule 182 and 183 of Orissa Treasury Code and recover the said amount.
Yes.
Then the petitioner approached the London State Administrative Tribunal,
right,
and there he got a stay order.
Right.
So, since the stay order was there, we could not file an execution case. Now, the moment the SAT dismissed the original application, the petitioner approached this honorable court in the present petition, and the stay order was obtained. So that restrained us from filing the.
Well, stay order is against the government, not against the state Handloom Weaver Corporate Society Limited, my lord. There is no bar at all by the court of law for filing the execution case by them, my lord.
So now you are now retired.
I am retired, my lord.
What is your total net worth, sir?
I do not know, my lord.
Very, very comfortable position, sir.
No, my lord. That if I have there is shortage, my lord, if there is a shortage,
all that they have to do is
cooperative society, my lord. They should follow the due course of law, my lord.
And
they have not followed
what
the
should
due
you
course
do,
of
sir?
recovery.
What should you do? You should do nothing.
No, why shall I do, my lord?
Your only task is to go and get stay. Whenever you want to go to a court, you get a stay.
Following the procedure, if they want to recover,
So
my lord,
there's something called
illegal comparative arbitrage.
Mr. Mohanty, I know your style of advocacy does not permit you to answer questions from the court.
My lord, I have practiced here for 35 years.
That's
my
right,
dear,
sir.
for 35
We are
years.
learning a lot. Every
But
day we
that
are
law,
learning.
my lord, law should follow, law should
Correct,
take
correct.
its own course, my
So
lord.
that's why I say
They have not filed the education case. I am
I'm
not
saying
liable to
something
take.
for a change. I'm saying something in your favor. You can listen to that, sir.
Yes, my lord.
We feel we are highly educated by a person like you, sir. Every day we get educated. Today again we are getting educated by the bar.
No, my lord, I am not saying so, my lord. That I am
No,
saying
no,
the law
we
should
are-
take its own
we are
course.
very obliged.
If they are not filed
We are
the
obliged
education
to you,
case,
sir.
I am not liable to pay one.
We are
rupee
obliged.
fee.
Correct, correct. We are obliged for that. We are obliged. We have not passed the order. Would you? Can we have it, audience, sir?
No, I think
While we
that
pass
you
the
are-
order.
Yeah, I think that you are also keep reserved the order, my lord.
No, I did not say that.
Yes, my lord. I presume, my lord, that.
All right. Unless even that we have to.
Yes,
You want to
my
say
lord, I
something on that?
presume, my
also.
lord. I'm sorry, my lord, but I beg apology.
All right. The present petition has been filed, challenging an order dated 17th April 2006, passed by the challenging two orders. One is an order dated 12th August 2004, passed by the Directorate of Textiles, Orissa, calling upon the petitioner ordering that a sum of rupees 14,16,442.40 recoverable from the petitioner pursuant to an award dated 1st November 2003 of the arbitrator command Directorate of Textiles, Orissa, is recoverable from the petitioner and ordering recovery from his salary under rules 182 and 183 of the Odisha Treasury Code, commencing the month of August 2004 till his retirement. The further challenge this present petition is to an order dated 17th April 2006 of the Odisha Administrative Tribunal, OAT, Bhubaneswar, in OA number 1028 of 2004, whereby the application filed by the petitioner challenging the above recovery order was dismissed. The OAT held that the failure by the absence of any attachment order by a court of law as required under Rule 182 of the Orissa Treasury Code was a single quote's mere technicality, unquote. And that sufficient opportunity had already been granted to the petitioner to pay the amount awarded against him. What weighed with the OAT was that petitioner never challenged the award which he contested, which was passed after he had contested the claim. Paragraph. The background facts are that for a period between 23rd April 1984 and 1st August 1989, the petitioner worked on deputation with the Orissa State Handloom Weavers Cooperative Society Limited, Bhubaneswar, bracket society. Full stop. According to the petitioner, long after he was repatriated to his parent department in the government of Odisha, he was informed that some shortage was detected on the basis of an audit report concerning the society. And the shortage was in the sum of rupees 792,046.08, which was liable to be recovered from him. Paragraph. A dispute ensued and was referred to the arbitrator under Section 68 of the Orissa Cooperative Societies Act 1962, bracket Act, and was registered as dispute case number 2 of 1997. Full stop. The petitioner contested the case by appearing before the arbitrator and making his submissions. Full stop. On 22nd March 2004, the arbitrator, on 1st November 2003, the arbitrator delivered the single quotes judgment, unquote, bracket award, holding that the society was entitled to recover from the petitioner the aforementioned sum together with 12% interest per annum from the date of filing of the dispute till the date of its realization. Paragraph. On 22nd March 2004, the secretary of the society wrote to the petitioner stating that in terms of the above award, judgment, he was liable to pay the society rupees 14,16,442.40, which included the interest amount. Full stop. When the petitioner did not respond to the above demand, the first impugned order dated 12th August 2004 was issued by the Directorate of Textiles, Orissa, stating that the amount would be recovered from the salary of the petitioner under Rules 182 and 183 of the OTC, commencing from August 2004. Paragraph. The petitioner then challenged the above order before the OAT by filing OA number 1028 of 2004. Till the said petition was disposed of by the second impugned order dated 17th April 2006 of the OAT, there was an interim stay restraining the society, restraining the Directorate of Textiles and Handlooms, Orissa, as well as the society from making any recovery pursuant to from the petitioner's salary pursuant to the order dated 12th August 2004. Paragraph. When the present petition was listed before this court on 14th August 2006, while directing notice to issue in the petition, this court ordered that no recovery would be made from the petitioner, open quotation, otherwise than in accordance with law relating to the execution of the award, unquote. Paragraph. The said interim order is continued till date. At the outset, Mr. Mahanti, the petitioner, informed the court that the petitioner had since superannuated. Full stop. The main plank of his submission is that without instituting a proper execution proceeding, the opposite party, society, could not seek to recover any amount from the petitioner pursuant to the award in terms of Rule 182 of the OTC. Full stop. Reliance was placed on the decision of this court in Swastik Agency with the State Bank of India, 2009 2 OLR 201. Give me that note also, please. Sir, kindly give me that note also. Yes, given a written note of such. This is the only judgment, sir, you're relying on?
Two judgments, my lord.
Which is the second one, sir?
That is, my lord, the 2009, another is 2005, volume 13.
And
SEC
competent authority. He also
477.
placed reliance on the decision in competent authority versus Baranagar, Jute Factory, 2005 13 SEC 477.
Paragraph 5 was
The central plank of the submission was that where a statute requires a particular act to be done in a particular manner, it has to be done in that manner alone. Correct. Mr. Das, learned counsel appearing for the opposite party, points out that the award dated 1st November 2003 became final. In other words, the petitioner did not question the award which required him to pay the society over rupees 14 lakhs. Full stop. The petitioner made no effort to make any payment whatsoever, constraining the society to resort to recovery by invoking Rule 182 of the OTC. Full stop. In response to the plea that an execution proceeding should have been instituted, Mr. Das points out that throughout there has been a stay of further steps to be taken by the society, first by the OAT and then by this court. And therefore, there was no occasion for execution proceedings. In fact,
I make pardon, my
against the
pardon to have a pause, my lord.
Society. Full stop. The above submissions have been considered. Full stop. In the first place, it must be noted that the award dated 1st November 2003 is quite categorical regarding the liability of the petitioner to make payment to the society of the principal sum of rupees 792,046.05, together with interest at 12% per annum. The petitioner does not even dispute that even way back as 22nd March 2004, he was liable to pay the society rupees 1416,442.40. Even today before this court, Mr. Mohanty did not even for a moment suggest that the petitioner is not liable to pay the society the aforementioned sum. Full stop. The burden of his song is only about procedure. Full stop. He repeatedly urged that without filing an execution proceedings, no step could be taken for the society to recover even 1 paise from him. Full stop. The fact of the matter is that for over 18 years now, for nearly 18 years now, the petitioner has avoided making any payment towards a fairly substantial liability of rupees 1416,442.40, which together with the further interest calculated from that date would indeed be a very, very substantial sum. The petitioner has superannuated in the meanwhile, and Mr. Mohanty quite glibly stated before the court that he does not even know what the net worth of his client is. Full stop. Paragraph. The court exercising jurisdiction under Article 226 of the Constitution is also a court of equity. It will have to be mindful of the interests of justice and ensure that in rigidly applying technical rules of procedure, the result is not miscarriage of justice. Full stop. A handloom weavers cooperative society, which is owed over rupees 15 lakhs for over 18 years, is rendered helpless in seeking to recover the amount on account of interim orders passed first by the OAT and then by this court, without any corresponding burden whatsoever on the petitioner. Full stop. It would have been ideal if the petitioner had been made conditional on the petitioner depositing at least some part of the amount for a stay to be granted. Full stop. However, that was not done. Full stop. Meanwhile, the petitioner has superannuated, and the court is not even informed what his present assets are. Paragraph. Turning to the decisions cited by the petitioner, it is seen that in Swastik Agency versus State Bank of India, bracket Supra, the case arose under the Sarfacy Act. Full stop. What appeared to have weighed with the court was that the property that was put to auction for recovering the dues of the bank appeared to have been greatly undervalued. Full stop. This is apparent from the following observation in para 71 of the judgment. Just take A to A. Paragraph. Even while the court in the said case set aside the auction sale, it put the petitioner to terms as it should have while exercising its jurisdiction under 226 of the Constitution. It specifically required the petitioner to deposit the recomputed demand from the bank within 4 weeks from the date of receipt, B to B, failing which the bank will be eligible. Therefore, even when the court detected a procedural illegality, the relief was molded to ensure that the equities are balanced and that the defaulting party, namely the petitioner in that case, was not allowed to escape liability by not making any payment whatsoever. Full stop. The decision in competent authority versus Baranagar Jute Factory Supra was in the context of the acquisition of land under the National Highways Act 1956. The notification which specified a plot number, a part whereof was intended to be acquired, did not specify that part. Stop. It is in that context it was held that the notification stood vitiated. Full stop. The court fails to appreciate how the said decision would come to the aid of the petitioner in the present context, which has been outlined here and before. Full stop. Even today, the petitioner is not prepared to even make a statement about discharging the humongous liability he owes to the cooperative society. Full stop. The petitioner has avoided the liability for over 18 years now. Full stop. Under Article 226 of the Constitution, the court does not consider it to be a balance of equities to simply quash the impugned orders requiring recovery to be made from the petitioner. Paragraph. From the submissions of Mr. Das, it appears that the opposite parties are conscious of the requirement of having to comply with Rule 182 of the OTC, and it's only because of the interim orders of this court that those steps were not taken. In the circumstances, the court sees no reason why it should interfere either with the order dated 22nd March 2004 or the subsequent order dated 17th April 2006 of the OAT. The interim order stands vacated, the petition is dismissed. But in the circumstances, no order is to costs.
One submission of one submission may be recorded, my lord. The amount is not the government money, and this cannot be recovered under Rule 182 and 183 of the Treasury Code, my lord.
All right.
And for the opposite party number 2 in this case, my lord.
So that submission may be recorded.
All right. I just need to announce to the court, Justice Patnaik has to go away as an emergency.
Oh.
So we'll try and reassemble at 2 o'clock.
Special list, item 1.
So what has happened in the Supreme Court, sir?
My lord, in this case, court has admitted and issue notice and counter to file an 8-3.
Notice has been issued without no stay.
I know. See, the only thing is either we follow one of those high courts, pass a long judgment, and we get tagged with this. The better thing is to wait for what Supreme Court has.
Yes,
It just avoids more litigation for all of you also.
There may be subject, sorry, there may be, I'm sorry.
Balance. Can it be placed after, I mean, in the first week of April? And
No, I doubt very much, sir. I think it's better to have it in June or July.
Yes.
Because I doubt very much, because their boards are very full there.
And the self-same issue is pending before this apex court.
Correct.
So July.
July, we'll keep
Interim
in
stay
July.
to continue all the matters.
But all of you are filing in trickles. Every day, 2 petitions, 1 petition.
In fact, I have 3 petitions. I have 3 petitions which I'll be requesting your lordships to kindly tag on and pass interim orders. Subject to your lordship's kind consideration.
So you have it with you.
My lords,
All right.
and Mr. Satpati Milord is appearing in those 3 cases.
All right, taken on
So
board.
may I be permitted to file these 3 memos?
Yeah.
And interim orders in 3 cases.
Yeah. No coercive steps till next day. Now you can say 4 weeks for counter rejoinder for the next day. And then the main matters, you say the court is informed that the specially petitioned civil 1767 of 2022, bracket Union of India versus Ashish Agarwal, arising from the judgment of the High Court of Judicature at Allahabad, is pending consideration. Notice has been issued in the said petition on 11th February 2022. In that view of the matter, these petitions are adjourned to 11 July at 2 p.m. Interim orders to continue. In petitions where replies have not been filed, the replies be filed within 8 weeks and rejoinder before the next date.
My lord, 2 matters in this batch of cases, my lord.
Yes.
They are not connected, my lord. The second matter in the first page of the list, 30312 of 2020, and 7th page last item, my lord, 35140.
312 and
30312 of 2020 and 35140 of 2021, my lord. At different issues, my lord, regarding 194C, my lord.
All right.
So they have been wrongly tagged.
Those 2 matters you say.
My lord, on the last occasion, the court had issued the notice WPC 35140.
1 minute, let me pass an order in these 2 matters which is just mentioned.
Same item.
Oh, you mean you are appearing in that very matter?
Yes, same matter, my lord. On the last occasion, notice was issued. So I appear for the OP5 on that matter.
Okay, all right. The list on
OP4, my lord. OP4.
List on 4th July. Those 2 matters, list on 4th July.
Your lordship, may I please? Your lordships.
4103, that is also connected to this.
Which one, sir?
4103 of 2022.
Is it an income tax matter? It's not even that.
It is an income tax matter. The issue is 263 at
So that 4103 you listed on 21st, 18 July.
I have a similar request, Milords. In writ petition 37362 of 2021, 3124 and 3762 of 2022. These matters, Milord, relate to Vivad Se Vishwas scheme, Milords. These matters, Milords, are not connected.
Right.
I pray, Milords, sometime in April, Milords.
Why? What's urgent?
Milords, it's under the Vivad Se Vishwas Act.
Those 3 matters of Mr. Acharya, 27 June.
Milords, pleadings maybe exchanged.
Yeah. If replies be filed, if not already done, within 8 weeks, rejoined with the next.
So I have a very small, humble submission, subject to your lordship's kind
Yes,
consideration.
yes.
My learned friend for the other side, Lord, he has stated that the matters are now pending before the appeals court. I bow down to it. There may be one practical difficulty, my lords, that we are before your lordship's court, my lords. The matter is being decided by the Honorable Supreme Court. Perchance, my lord, if it is decided against the assessee, my lords, all these petitioners, they'll be deprived of the chance of approaching the Honorable Supreme Court, because that once the Honorable Supreme Court decides, that will be binding for.
Not at all, Mr. Kerr. You know how resourceful lawyers are. They get it referred to a larger bench.
Those curatives,
endless.
With your lordship's vast experience,
So
curative
3 to
petition.
5 to 7, it keeps going.
In
So
the meanwhile, my lords, there's another court, the Honorable Madras High Court, has also passed a judgment in February 1st week in favor of the SSC.
Right.
Following all those judgments of Allahabad, Rajasthan, and Calcutta.
Correct.
And
The lordships are keeping these matters to July.
Yeah, July 11th, I said. 11 July.
11 July.
Lordship, may
11
just
July.
say that 4103 a little bit small in the next week or day.
What's the urgency, sir?
In any case, I am.
No, it's all right. Let it come. The income tax matters can all wait. There are so many other urgent.
Those three matters which I mentioned, Lord, I've given memos.
Yes.
Your lordship will also pass interim orders in
No,
those.
there are interim orders.
Greatly obliged.
All right.
May I please, my lord?
Yes.
May I please, my lord? My lord, WPC number 36987, 2020. In this case, the approval is from JCIT. So I would like this can be disposed of on those issues. Because the approval is not
appearing. Mr. Chimankar or Mr. Satpathy?
Yes, sir.
No, in Mr. Ragnaraj Manti's matter.
Yes.
36, my lord.
This is Mr. Mahapatra.
My lord.
36987, 2021. Here the approval is from the JCIT, not from the principal CIT or CIT. This can be decided.
Yeah. 36987, the impugn notice under 148 has been issued with the approval of the joint CIT and not the CIT. Following the order dated dash of this court in writ petition dash, the impugn notice is
Writ petition number 20919 of 2021, decided on 21 January 2022, 24 January 2022.
right, 24 January 2022. The impugn notice is quashed.
My lord, another writ petition 36990. In this case, the notice has been issued more than 6 years. That is, the assessment is 1314. It has been issued a lapse of 6 years, so barred by limitation. Cases has been posted for hearing on 14th of March. This can be taken up on 14th.
Mr. Please tell me what is the name of the assessee. We are not.
That is
Ravi Metals, my lord.
Ravi Metals Limited 36990. Assessment year 1314.
Yes, my, in that case, I am agree.
Ravi Metallics.
Yes, ma'am.
All right.
36990.
980 list on 14 March. All right.
Similarly, Millards, this issue where the approval of the JCIT, Millards, is granted to a petition and it is beyond 4 years, and in case of a approval by PCIT, it is beyond 6 years. Because there are 5 writ petitions which already
in those
stand
cases,
covered.
my lord. My lord,
We will give a chart for all the writ petition.
What I submit, Millards, 14th March is the date fixed. Your lordship may take up these 5 on that day, Millards.
All right. Give us those numbers. Those 5 petitions will be on 14th March. All right.
I may be pardoned to make a mention, your lordship.
I'll give it in a chat, Millards.
Yes.
Obliged, ma'am.
2 matters tagged in this bunch of matter, your lordships. These are already covered by your lordships order dated 24 January 2022, your lordships. So these two are 3
covered in what way?
Because these are the beyond 6 years, sir.
Sorry?
Beyond 6 years, your lordships.
Beyond 6 years, but will come on 14 March, I think, no? Beyond 6 years means it comes on 14 March.
Yes, 14 months. 14 months.
So what are the numbers, Ms. Roy Chaudhary?
These are 36539.
Sorry?
36539 of 2021.
Just make a note of her numbers. 36539.
and 35607.
35607, list on 14 March. All right.
We have to check it with the.
No, that for lots of.
Mr. Mahapatra is appearing in these matters.
All right.
You already fixed the matter so that we can check it out, so that your lordship fix in 14 all the matter, those who are taking, saying that it is covered.
Yeah, that's
Yes,
right.
yes.
That's right.
And I have passed on the similar order, or the order of 24 January that my learned senior Ms. Ms. Chaudhary was relying upon.
Right.
That's
All right. All right.
grateful.
Okay.
Three matters, 13, 14.
Already done.
No, so I have not given those three matters where it's beyond 6 years. Your lordships are fixing it to March.
14 March.
14 March. So that is WPC 4645 of 2022, 4649 of 2022, and 5360 of 2022.
All right.
Lordships, another two matters I have given the memo today morning before the court master, lordships. These are all, these two were covered by your lordships order dated 24th January. I have annexed the order also at annexer 2.
Covered in what sense?
Covered, it is passed by ITO lordships.
Passed by?
Income tax officer lordships.
I see. You mean
JCIT, approved by JCIT.
JCIT. All right.
Yes.
So the same order as JCIT, these two.
Let it come on 14, my lord. I'll check it up, my lord. I pray it may be taken up on 14.
No. Let's not mix up things, sir. This is joint CIT's approval, prior approval.
Yes, my lord. That is there.
It's all right. Yeah.
Oh, bless.
My lord, pardon. That is WPC 38320 of 2021. That is beyond 6 years. That will March on.
All right.
38320 of 21.
Lordship, beyond 6 years, two cases, 1167 of 2022 and 1649 of 2022.
All right. Good.
Special weekly list, item number 17.
The petitioner, my lord, is a priority industry, and this was covered under 1996 IPR, madam. Where 7 years was granted for 7 years exemption from sales tax, that from the date of commencement in 2001. Now, during the pendency of the exemption period, my lord, in 2005, the Orissa value-added tax was introduced with effect from 1/4/2005, and under the act, whosoever was entitled to exemption was now allowed deferment of tax. So that deferment and subject to terms and conditions for which a separate notification has to be issued. Now, no notification was issued, and notice and annexure 4 was so-called notice was issued for payment of tax, for which I filed so-called and I came before your lordship. The lordship granted me interim protection.
What is the value involved? 1 year's tax, no?
Sorry, my lord.
Only 1 year's tax.
1 year and 2 months pay extra. Now, my lord, what has happened? Here, thereafter, notification has come and I have been allowed deferment of tax.
So nothing
my
survives
prayer has
then?
been allowed. 1 and 2 has been allowed. Only that so-called notice I have filed my reply, that has become infructuous, lordship.
All right.
Your lordship, entire writ petition has been infructuous.
All right.
Why your
Both
lordship?
parties agree that the writ petition has become infructuous, is disposed of as such.
So also
All
the
right.
so-called notice, man.
All right.
Special weekly list, item number 18.
None appears. Dismissed from number.
No, Millers, I am appearing. May I please, your lordship?
All right. All right.
Millers, this is a case where a lease was granted in respect of a particular land to a person, namely Adhikari Bhoi. In the year 1900.
So you are a bona fide third party purchaser.
Millers?
You are a bona fide third party purchaser or something?
Third party purchaser and he
Without
was not
notice.
noticed. It is to be
So it has to
removed.
go back.
Yes.
I have got, Millers, I have given 3 judgments of this honorable
Yes,
court.
we're sending it back to ADM. We'll send it back to the ADM.
This order has to be quashed first, Millers.
So we are sending it back to the ADM. You'll appear
All right.
before the ADM. All right.
Okay.
Yeah. The petitioner is a bona fide third party purchaser from the erstwhile leaseholder whose lease has been cancelled with impugned order dated 21st September 1987. of the Additional District Magistrate Bhubaneswar in revision case number 741 of 1987. On the short ground that no notice was issued to the present petitioner, the impugned order is set aside. Revision case number 741 of 1987 will now be listed before the ADM Bhubaneswar on 18th April 2022, on which date the petitioner will appear along with a downloaded certified copy of this order. The ADM is requested to proceed in the matter afresh, uninfluenced by the earlier order, and after hearing the parties, dispose of the revision case within a period of 6 months thereafter. The status quo as of today be maintained till the disposal of the revision case. The petition is disposed of.
Special weekly list item number 19. Special weekly list item 19.
None appears dismissed.
I am for the opposite part.
Item number 20.
Item 20, my lord. The council appearing for the petitioner is no more, my lord. My lord, I undertake to appear, lord, may call it 10 days after.
No, we're not adjourning it, sir.
My lord, it is, the council is no more, my lord.
When did he pass away, sir?
Lord, next week, my lord.
When did he pass away, sir?
My lord.
When did the council pass away?
No, he has passed last 1 year, my lord. More than 1
It's
year.
all right. We're not adjourning. We can pass over. You please get ready.
My lord,
Item
well, the brief is not with me. Next week, my lord.
No,
Any day
whenever
next
you
week.
find the brief, you revive it, sir. Council, the petitioner. Have you filed your wakalatnama?
My lord, I will file tomorrow.
No. Not
Tomorrow,
like this,
sir.
Don't take it so casually, sir. Please, sorry.
No, sir.
No, sir.
All of a sudden,
We
it has
don't
come,
have
my
that
lord.
luxury of time, sir.
No,
Please.
my lord.
Don't take it so
only
casually.
only one time, my lord.
No, sir. If you want, we'll pass it over. You get ready with the matter.
Yeah.
Don't take it so casually, sir.
Your lordship's brief. may
Sorry,
be-
sorry.
I may permitted to go, your lordship.
No.
Your lordship's brief. my
Counsel
lord.
to the petitioner, without having a paper book in his hand and not having the brief at all, wants an adjournment. The court is not inclined to do so. The petition is dismissed for non-prosecution. It will, however, be open to the petitioner whenever he locates the brief to seek its restitution.
My lord, may I let it come tomorrow, my lord. I will
Yes,
assist,
yes.
my lord.
All right.
Lordship,
I am for open
item
number 3, my
19
lord.
dismissed.
Item number 21.
Tomorrow, my lord. My lord, may I tomorrow, my lord.
Who's in 21, sir?
Special
Item
weekly list
19
item
has been
21.
dismissed. Item 19 has been dismissed for non-prosecution.
Yes.
Public.
Item 21, my lord.
My lord, here in this case, the petitioner has been dismissed from service as a police constable for having 11 black marks. I may indulge lordship's attention to police manual, my lord. Rule 834, I may be permitted to read, my lord.
Yes.
Imposition of black marks. Black marks may be awarded alone or in addition to other punishments enumerated in Rule 824, except dismissal or removal to all officers of and below the rank of inspector.
What is the age of your petitioner now, sir?
My lord, now by age is 70 above, my lord. But here it's a dismissal, 19 year service, pensionable.
All right, tell us.
My lord, the to all officers of below and below the rank of inspector, no more than one black mark shall be awarded or any offense except when moral turpitude can reasonably be inferred. I will indulge lordship's attention to page number 5 of my writ application, my lord, original application, wherein in the DP number 32/81, lordship got page number 5, 2 black marks. In one proceeding, 2 black marks. In the second proceeding, in 81, 1 black mark. Third proceeding, 2 black marks. But the law speaks that in no proceeding, more than 1 black mark can be awarded. However, if it is a moral turpitude which can be reasonably inferred, in that event, only black marks to more than 1 black marks can be inflicted. But here in this case, only unauthorized absence for some days.
Come to page 29, sir. Come to the order of the tribunal.
My lord. My lord, I'll read the operative part, my lord.
No, the paragraph, it appears.
Paragraph?
The paragraph beginning, it appears.
Yes, my lord. After hearing the Learned Counsel for
No,
the-
sir. Page 29.
Yes, my lord.
There's a paragraph, it says it appears, it starts.
Yes, my lord, I'm reading. It appears that under Rule 836 of the Orissa Police Manual, 9 black marks shall be entailed reduction in rank or compulsory retirement or removal or dismissal. Under Rule 837(2), it is further indicated that the order awarding black marks shall specify the number of black marks outstanding against the delinquent, and a warning is necessary before dismissal due to imposition of black marks. It appears from Annexure 4 that on 4/10/1985, it was brought to the notice of the present applicant that he had already earned 6 black marks, and adding 2 more, the total black marks came to 8. And accordingly, he was also warned in writing to be careful in future, in as much as another extra black mark will entail dismissal from service. In spite of such warning, no attempt was made by the applicant to render good service or to improve his record in terms of the Orissa Police Manual, and subsequently he went on with his usual practice of misconduct and delinquency, for which in 1992-93 he was given 3 more black marks with due notice. Thus, he earned 11 black marks, thereby justifying the order of dismissal. The disciplinary authority as well as the appellate authority took into consideration.
So what is your submission, sir?
My lord, my humble submission, under Rule 834, unless it is a moral turpitude reasonably inferred, more than 1 black marks cannot be awarded. In page number 5, Lord,
Yes.
in 6 proceedings, 2 proceedings I was given 1 black marks. Another 4 proceedings attested 2 black marks. But no.
What were you, sir? What were you when you were working in the police? What were you? What was your
Constable. Constable.
Constable. All right.
But contrary to the rule, on 4 occasions, 2
Yes.
black marks awarded. Black marks, more than 1 can be awarded. Only, provided it is moral turpitude, which can be reasonably inferred under Rule 834.
Right.
But on 6 occasions, 2 occasions I was given 1 black mark for unauthorized absence.
Yes.
All the 6 occasions, unauthorized absence.
Yes.
But on no occasion, it cannot be, unless it is moral turpitude, reasonably inferred, no more than 1 cannot be inflicted. Had it been so, I would have been inflicted with 6 black marks on 6 proceedings.
Yes. The challenge in the present petition is to an order dated 18 November 2005, passed by the Orissa Administrative Tribunal Bhubaneswar in OA number 2262 of 2002. The challenge in the said petition was to an order dated 2nd July 1996, passed by the Superintendent of Police, Rayagada, being the disciplinary authority bracket DA, who accepted the report of the inquiry officer bracket IO in respect of the charges leveled against the petitioner. Full stop. The punishment of dismissal from service was awarded to the petitioner. Paragraph. After the statutory appeals were dismissed, the aforementioned OA was filed before the OAT. Paragraph. According to the petitioner, the punishment awarded was disproportionate to the alleged misconduct. Full stop. It was argued that not more than 1 black mark should be awarded for any offense in terms of Rule 834 of the Orissa Police Manual, except when moral turpitude can be reasonably inferred. Full stop. The reasoning weighed with the OAT for dismissing the petition reads as under, take page 29. It appears up to the last paragraph. Clearly, as far as the petition is concerned, the black marks were awarded over a period of time. Stop. Way back on 4th October 1985 itself, the petitioner had been warned that he had already earned 6 black marks. Full stop. Rule 834 cannot be stretched to mean that there cannot be more than 1 black mark in an entire career. It only probably means that there cannot be more than 1 black mark at a given point in time. Paragraph. The petitioner had been warned that earning of more black marks would entail dismissal from service, full stop. Despite this, during 92-93, the petitioner ended up earning 3 more black marks. Paragraph. In the circumstances, the court is not impressed with the argument that the petitioner ought not have been awarded more than 1 black mark. Full stop. To set the record straight, the petitioner has earned as many as 11 black marks, considering that he was a constable in the police force, where the highest degree of discipline is to be maintained. The court doesn't consider the punishment awarded to be disproportionate. The petition is dismissed.
Special weekly list item 22.
Lordship, item 22, no instruction.
No instructions.
Item 23.
May I please, your lordships. My lord, the petitioner availed a loan from Orissa State Financial Corporation for setting up of a hotel in Quebec in 1980. On the allegation of default being committed, your lordship, the unit came to be seized in 88 and handed over to another unit, another hotel, under a leave and license arrangement, who continued to occupy the same until 1998. And ultimately, it was delivered back to me on 10th of June to 1998, your lordship. In the meantime, pursuant to meeting held, I deposited the entire outstanding dues concerning the different financial institutions. However, the property, though they issued initially, they agreed to deliver me the property back, that did not. And they said, we are not able to deliver you the property because of interim order granted by Civil Court of Bhubaneswar, your lordship. Now, question is this leave and license arrangement with the other party, my lord, why am before your lordship, that it was rented out at 27 lakhs per annum to that Kenilworth party, my lord. So in the 10 years time, they have collected more than 3 crores. Now, as per 27(4) of the, 29(4) of the SFC Act, they being the trustee, your lordship, I have been claiming this amount from them ever since then. And in this connection, your lordship, may kindly look at their response.
What is your prayer, sir?
My prayer is for the money, my lord, that they have collected from the.
What is the sum? What have they collected?
I am not clear, lordship. They delivered it to another hotelier.
No, come to prayer B.
To refund the balance surplus.
What does that mean, sir?
I had some liability. They collected my.
No, it's all vague. Suppose we allow prayer B and they pay you nothing, you're very happy. There is no specified sum in your prayer.
That is there in one of the documents, your lordship.
So
the amount I have not specified, your lordship is saying.
Are you clear? What is the amount you're seeking?
Your lordship may kindly look at last documents that they have filed to the brief that they had issued. My lordship, looking at that.
You have to tell us a page number, sir. All right.
129. My lord, 129.
129.
How many pages are there in your paper? Yes.
This I understand amount is 3 crores 11 lakhs somewhat.
Page 129 is a letter addressed to you of 10th/11
July 2007. Yes, my lord. The Orissa State Financial Corporation response to my letter, the previous page, my lord, June 18th letter, in which I had requested refund of balance amount of fixed annual rent of occupying or mortgaged hotel property by you from 12/2/1988 till 10/6/1998. That was it, 27 lakhs per annum. That was the arrangement made. In response to this, the corporations in the next page says that the license fee and interest received by the corporation was duly adjusted, appropriated, distributed, and balance refunded to you in terms of such and such. Read with section the pari passu agreement. The corporation is not liable to refund any amount unless the balance license fee and interest thereon are received from Messrs. New Kenilworth Hotel. To this hotel, they had delivered the property also. The license, as per the provision of section 29(4) of the SFC Act, read with pari passu agreement. The corporation has already filed a suit for recovery of the balance license fee and interest thereon against the said licensee before the civil judge in Division, Bhubaneswar. So, my lord, as regards charging of interest, so I have to wait till that is decided, that civil suit. So they don't say no, they owe me 3 crores 11 lakhs.
Yes, what is your response, sir?
My lord, this letter, my lord, if my lord will see.
Was notice issued in this petition?
My lord.
It was issued possibly, my lord.
Yes, my lord.
Yes, on 28th September 2007.
2000. My lord, my submission is this.
No, have you filed a reply, sir?
No, I have to file a reply.
You have not filed a reply
No, my
for
lord.
15 years.
Yes, my lord. That is the whole problem. My
We'll
lord.
simply allow the petition, sir, then.
Sorry, my lord.
No, you don't have to be sorry. Why should you be sorry?
I have written a multiple number of letters. My
So
lord,
it's okay, which means they
can't-
accept the petition. We just proceed on the basis they accept everything that is said in the petition. What is your information? What is the present status of that suit? Do you have any information?
No, my lord, I don't have any.
No, what about you, Mr.
They
Sani?
are the plaintiff, your lordship.
No, should we simply allow your petition?
My lord,
We should simply allow your petition. That serves your purpose.
it should, my lord. And that amount, your lordship, specifying page 24, paragraph 53.
At the best, my lord, I can only confirm to the whatever, my lord, that 129, that the letter we have written to him, that is my only, can be my only
Correct.
response to
Correct. And that's not even a fair response,
My
because
lord,
why should he
I-
wait
I-
till your
I
suit is
accept, my lord.
decided?
I fully accept that.
We'll pass the detailed order. You say a direction is issued to the opposite parties to refund to the petitioner the sum due to it, together with interest at 6% per annum from the date fell due till the date of payment, which in any event should not be later than 9th May 2022. If the payment is not made by that date, the petitioner will be entitled to simple interest at 9% per annum on the aforementioned sum for the period of delay. We'll pass the detailed order. This is the
My lord,
operative.
can I make one submission, my lord, with permission of the, my lord? My lord, let it be subject to the result of the suit, my lord.
We're not agreeing to that, sir.
My
We're not
lord.
agreeing.
All right.
Special weekly list item 24.
24 ITA, the respondent has already entered appearance. Here is a case. I have framed the question.
What is the
And it's
tax
supported-
effect here, sir?
Tax is not above the limit.
Sorry?
Above the limit. And here is a case, here the question has already been answered with two courts. I mean, the Punjab and Haryana and the Bombay High Court. The issue is squarely covered by the judgment. The issue is, I have page 4 of my appeal memo. Whether the current tribunal is correct in law to hold that the notice under section 158 BC was invalid, and according to the assessment made consequent upon the same was also invalid. Here the case is that before the tribunal, that notice has been issued by the authority, but after receiving the notice, the 15 days which has been the specified, that 15 days period has to be there, that is not there. Due to process delay, he has received, but he has now asked for time, and therefore the assessment was passed. Thereafter is filed the return as contemplated in section 158 BC. Now the tribunal say the notice is invalid because you are not allowed time 15 days. You also know that 158 BC is a procedure for assessment, not as good as 140.
No, just come to the impugned order. Which paragraph you are talking about?
Yes, Your Lordship. page 55, paragraph 12.
12.
Yes. Ground number 2, in with regard to the validity of notice which has already been dealt by our order in group case number so and so.
What has happened in that group case, sir?
That will not die.
Then, following the rule of consistency, this should go then.
No, my lord, but here is a legal.
We'll leave all that open, sir.
But you will also kindly because these two High Court has already given the answer in favor of the department.
Involving the same SSC in the group case with all those appeals already having been decided against, why should we?
But I have, because I have collected the brief from your lordship's brief. Therefore,
whatever.
So your lordship say that my statement may be recorded. Your lordship may.
All right.
And I'm listening these two judgments. Your lordship kindly have it.
This appeal by the revenue is directed against an order dated 4th September 2006 passed by the Income Tax Appellate Tribunal, Cuttack Bench, Cuttack. Bracket IT 18, IT bracket SS bracket A number 15/CTK/2005 and CO number 49/CTK/2005 to the block period 1990-91 to 2000-01. This appeal is yet to be admitted. The question sought to be urged is whether the ITAT was correct in law in holding that the notice issued to the SSC under section 158 capital B capital C of the Income Tax Act 1961 bracket Act was invalid. Paragraph, a perusal of the impugned order. The perusal of para 12 of the impugned order reveals that the said question was answered against the revenue by following the ITAT's earlier order in the group case in IT bracket SS bracket A numbers 16, 17, 23, 24, 30, 79, 80, 81, etc., which had all been decided against the revenue. In other words, the ITAT was merely being consistent with the decision already taken by it in several other connected appeals involving the same question. And in relation to entities that were part of the same group. Paragraph. Following the rule of consistency, the court is not therefore inclined to frame the question as urged. The appeal is dismissed.
Lordship, kindly refer my judgment which I have signed.
Not necessary, sir, that you don't know what has happened in those appeals. Yes.
Lordship, in this case, I am appearing behalf of opposite party. Kindly recorded my name, Lordship.
All right.
Lordship.
Item 25.
May I please? Annexure 14 series representation are pending before the opposite parties 2, 3, and 4 for leasing out the land in favor of the petition institution and revalidation of sanction by waiving the premium, my lord.
So we don't know what's happened in all these intervening years. You make a fresh representation, sir.
My lord, I'll find.
All right. Counsel, the petitioner seeks. This is 5585 of 2008.
My lord.
All right. The petitioner seeks leave to withdraw this present petition to make a fresh representation to the authorities in accordance with law. Disposed of is withdrawn with liberty spread.
Special weekly list item 26.
In item 25, I pay for the opposite party number 5. My presence will record.
All right.
Obliged.
Special weekly list item 26.
For item 26, there's a batch of matters.
Yes.
Which you permit. But I'm in the third one, in fact. If you look at my matter is WPC 4743.
How long will this take, sir?
It will take some time because this is a matter regarding the death come to retirement gratuity to the retired district judges.
I see. We'll have it on some other days, sir, because we may not be sitting in the same combination.
Your Lordship.
List on 22nd June.
Your Lordship.
Not 22nd? 22nd June.
June.
Special weekly list item 27.
None appears dismissed now.
Item 27, my lord, I am for the opposite party. Opposite
Follow the next matter, sir.
Special weekly list item 28.
May it please this honorable court. I'm appearing for the petitioners in all the three matters. May I kindly take up the third matter first.
Yes.
In this matters, the petitioners have challenged the e-auction policy, coal e-auction policy. Now the issue has been decided by the Honorable Supreme Court, and there are three concurrent decisions now. We have given the filed the cases by way of a compilation now. I'll just give a short background to the case.
No, again, sir, how long will it take?
10 minutes, my lords.
Who's for the other side?
MCL.
Who's appearing for
Mahanadi
them?
Coalfields.
Who's appearing for them?
Mr. Das, you are appearing with this first.
I am appearing for the government of India, my lord. On the earlier occasions, if I'm correct, my lord, my learned senior Mr. Sanjit Mahanti was appearing for MCL.
No, Mr. Naresh Sahu.
Pardon, man, I am there. I am on DC mode, my FC.
Yes.
I have all the cases I am appearing for up 2 and 3 minutes.
No, he says it's covered in his favor by the Supreme Court judgment.
There are other issues, my lord. My lord, so read petition was filed in 2005 minutes. All three read petitions. One is of 2009, other two is of 2005. Only two matters. One 2009 matter also connected with another 2005 matter. Initially, we have taken a objection with regard to maintainability of the read petition. This matter was heard on 7 to 8 occasions in 2011. In the 2015, they have filed an amendment in thereafter in 2016, the amendment was allowed. Our very objection was with regard to maintainability. My lordship knows under section 291 of the Companies Act 1956, only the board of directors or the persons authorized by the board
Anyway,
they can.
We'll have it on some other day because in this combination we may not be continuing to sit. So.
Yes, yes, my.
It's on 12th July. All right.
Oh, please, ma'am.
Item 29, special weekly list, item 29.
No instruction, Major.
Council petitioner states he has no instructions.
Item 30. Special weekly list, item 30.
None appears this was not possible.
Item 31. Item 31.
31, my lord, I am appearing for ICO.
I am appearing for the municipality, my lord. Petitioners are there to submit before lordship first.
Who is the petitioner? None appears to the petitioner.
They have obtained a stay order since 2009, my lord. We are
Only thing that,
seeking
my lord,
vacation.
even though I am not in the petitioner over here, but the ITCO stand was that they are not liable to collect tax, but that is the whole ratio.
Anyway, you said none appears to the petitioner.
My lord, I am appearing for the petitioner in the seconded application.
In the?
In WPC 15540/2006.
All right. In 17804, none appears dismissal non-prosecution. Yes. Tell us in this.
My lord, challenges to annex.
1 minute. Who appears in the third, fourth, and all?
My lord, I am there for first, that is 17804.
No, we are for the petitioner, sir.
No, my lord. Sorry.
Who's appearing for the petitioner in the other two matters? 16072, 12206. 12207. 1221.
My lord, in this case, the party has taken the file from me to engage some other advocates. That's why I not appear in this case. My name is KK Jana. My name may be.
So in all of KK Jana's matter, you say, Mr. KK Jana, this is, you take from all of KK Jana's matters. 16072, you say none appears, dismissal non-prosecution.
I'm appearing for it.
12206, 209, 211, 212, 213, 214, 215, 216.
But
you say Mr. Jena states that the papers have been taken away from him. None appears on behalf of the petitioners, dismissal non-prosecution. 17296, who's appearing? Again, none appears, dismissal non-prosecution. So the only matter that survives is this Reliance
Yes, my lord. Reliance and my lord in the other writ applications from 1/2/06 of 2017 till the last matter, I'm appearing on behalf of IDCO.
No, that's okay. We've dismissed that from our
all right.
first. In Reliance Industries, you're appearing for Reliance.
I'm appearing for the petitioner. It's
Ah,
a
tell us.
2006 matter.
Tell us.
Yes, my lord. My lord, here the challenges to Annexure 1 and 2, which is the notice for imposition of holding tax. But my lord, in the meantime, I just want to bring this to my lordship's attention because in the other writ applications, there is an order of the government, the opposite party government regarding holding tax, which is not annexed in the other writ application. If your lordship will kindly take up WPC 12206 just for reference. 12206 of 2017. Annexure 5.
Yes. Right. Appealable. Yes.
Yes, my lord. So, my lord, this is a notification of the year 2015, which deals with assessment and collection of property tax as well as holding tax. When I filed the writ application in 2006, this notification was not there.
So you can avail of this?
Yes, my lord.
So you want to avail of this notification?
My lord, yes, my lord. I would like to add this by way of an amendment. The lordship allows me. Although it's a 2006 matter.
No.
If your lordship sees the notification in para 1 and para 2, the government has specified regarding the levy of holding tax and how it is to be shared between IDCO and between urban local bodies.
Right.
So, my lord, this notification was not present when I had filed the writ application in 2006.
All right. You say counsel the petitioner in this 15540 of 2006 states that the petitioner would like to raise a challenge to a resolution dated 13 November 2015 issued by the Housing and Urban Development Department, Government of Orissa, which has a direct bearing on the subject matter of the present petition. At her request list on 2nd May.
Obliged.
Let them serve a copy on me. I will file a rejoinder to that.
I will.
Item 32. Special weekly list, item 32.
My lord, item 32, my lord, I pray for an adjournment.
Your lordship, I beg pardon. In item 31, my lord, during the 31-7 matters, I'm on behalf of Mr. Anand Chandra Sai. He was there, my lord, in the court, my lord. But all of a sudden, he didn't feel well for that reason. I pray, my lord, kindly taken up along with the first item, my lord. I'm on behalf of Mr. Anand Chandra Swami, Lord. He didn't feel well, my lord.
No, only one matter he's appearing.
One matter has been taken up and another was dismissed, my lord.
No, so that 16072. He's appearing in 16072, right?
No, altogether 7 matters I have, my lord.
No, but Mr. Jena was appearing in all those matters.
Probably saying 17804, maybe.
17804 and 1607.
I am on behalf of Mr. Anand Chandra Swami.
What are the matters you are appearing in, sir?
2 matters. You are appearing in 2 matters.
Yes, my lord.
That is fast rate petition and third one.
Yes, your lord.
So 17804 and 16072, you say later on, what is your name, sir?
L.N. Rohit Singh.
Sorry?
L.N. Rohit Singh. Lakshminarayan Rohit Singh.
Appears and states that Mr. Anand Chandra Sai is unwell today. So list on the same list on 2nd May. All right.
Item 32.
My lord, item 32, I pray for an adjournment, my lord. Mr. IR is engaged in this case. He has been Calcutta for his treatment, my lord. Next week or any other date.
What is the matter about, sir? First tell us that.
But it is from against the order of the State Administrative Tribunal, my lord.
What is it about?
My lord. But next week, my lord, if he doesn't come,
Tell us what is the matter about, sir?
My lord, the file is with him. That's why I'm unable to address your lordship, my lord. I pray for a single
1 minute, sir. Let us try and find out what the matter is about. All right.
The original petitioner died. Thereafter, substitution has been carried out, my lord. Wife and sons, my lord, children. Thereafter, the wife of the petitioner has also been died, my lord. In the meantime, my lord.
How is the matter surviving? I don't understand. What was the main prayer in the petition?
He was dismissed for service. Later on, my lord, he was acquitted from the charges.
So he's been reinstated with effect from 27/4/84.
Department proceeding of 18/11/1986.
I know. What survives in this kind of matter, sir? Why are we holding on to this kind of a matter?
My lord, because the reason for which he was dismissed from service, my lord,
No,
he has been
reinstated,
acquitted
sir.
later on, my lord. He has been acquitted later on in criminal revision by this honorable court.
He has been reinstated, sir.
And he was 74 years by the time of filing.
So the legal heirs are all married daughters. Some son is all 50 years, 54 years. Why should we? What are they going to get? I don't understand. The what? You say the court has perused the application for substitution, which shows from the legal, which encloses the legal heir certificate. The petitioner informs the court that the wife of the original petitioner has also died. Full stop. All the children are well above 50 years old as of today, and some are even more than 60 years old. In the circumstances, the court sees no reason to keep the present petition pending. It is dismissed as such. Yes.
Special weekly list item 33.
My lord, maybe excused. That item 31, your lordship posted on 2nd May. On that impression I left, my lord, my matter has been dismissed for non-proceed. My lord, WPC 17/296 of 17.
All right. That last matter you put on 2nd. All right.
Obliged.
Item 33. Special weekly list item 33.
The question of law is at page 7, my lords. Whether on the facts and in the circumstances of the case, the activity was right in law
In holding that assessee explanation with regard to addition of.
We'll take it on some other day. We'll take
My
it.
lord.
List on 10th May. All right.
Special weekly list item 34.
Petitioner, my lords, the filed the state of writ appeal challenging the order of the honorable single judge by the annexed 10, my lords. I am giving a short head check, my lords.
We'll have it on some other day. List on 17th May. All right.
Special weekly list item 35.
Please, madam. My lord, in this matter, I am challenging the order passed by the law and tribunal. My lord, my prayer is that to treat myself as par with the others, because there was a panel prepared by the opposite party, basing on
for
that.
which year, sir? For which year is
2006. 2006. What happened in the panel? The 2005, the panel was prepared basing on the merit. I was in the serial number 12. What they have done? One junior who has also given a fake certificate got an appointment. Thereafter, subsequently the medical officer was called for by the tribunal, and his appointment, her appointment was also cancelled. I was given the appointment. Only thing is, because there were 2 years had been elapsed during that period, that to give me appointment, because others are also
Not
given.
possible to give you relief, sir. What is your age now? What is the post?
No, I am continuing that post. I am continuing at that post. And only my prayer is that treat me par with others. Since 2005, the others are also engaged and also treated as regular. I should be treated as regular. Only the 2 years in between that, because I approached the tribunal to get an order, to get an appointment, and the person who has also manipulated the certificate got appointment, and she has been removed. Only thing is they have to treat me as a regular par with others. That the 2 years maybe that is there, nothing more.
In the year 2006, the advertisement was made, my lord. And the petitioner was at serial number 12. But the petitioner who was in serial number 11, the applicant who was in serial number 11, he got the job because there are only 3 posts for the unreserved category, my lord. Thereafter, my lord, subsequently it was found that the serial number 2 applicant had given a fake certificate, and therefore he was removed from that post. And the petitioner approached before the learned state administrative tribunal in the year 2007, saying that since one post remained vacant because the person who has given a fake certificate, he has been removed, my application may be considered. Thereafter, he was given appointment in the year 2008. Now she is claiming that she should be regularized, or she should be her pay scale should be fixed from the date of par with others. Yes, but it cannot be done, my lord. For the period 2006 to 2008, my lord.
All right. This doesn't.
Pardon, my lord?
We'll pass the order. You don't have a right, sir, because you came in only because the slot.
Only thing, my lord, also know. Suppose the candidate who has given the fake certificate got appointment. If she could not be there, then I should be there. I should not come
it's
to
not
the
automatic, sir. It's
pardon?
not automatic. It's only when she goes that you come in.
No, because they are adopting the fraud practice. Fraud practice is only by the opposite party, the medical officer. Unless and until the medical officer should appear before the tribunal, right. He will not cancel the appointment.
Right.
Because he was appear in person, then cancel the appointment, and in that case I got appointment. Right. Because the panel list has been prepared by the opposite party. Including that panel, I am also one of the selected candidate and meritorious candidate. Right. Why should I be divided if others are getting the benefit? Why not me?
All right. Dismissed. We'll pass the detail. Right.
Special weekly list item 36.
By last order, your lordship directed the opposite party to file a report in shape of affidavit by serving me an advance copy.
Lordship may kindly see the notice which is under challenge. The impugned notice is at
the
page
report
12.
has been filed, but I have not been served with a copy. Let
me place before your lordship what is the case. The lordship may kindly have a glance over page 12, annexure 1, which is impugned.
No, last order, we'd asked the Tahsildar to submit a report. What happened?
Yes, that report is there, but only
but
thing
I have not been served with a copy, my lord, as per the
not filed today. I have obtained the order, but one
first
thing
do it, sir. Today, let us logically carry the last order first.
It's okay.
All right. This is counsel for the Mr. Devakant Manti, learned AGA, states that the report of the Tahsildar is being filed today.
No, not today. It is already, we'll file it within 2 days.
Okay, will be filed within 2 days with an advance copy to counsel the petitioner, who is permitted to file a response thereto before the next date. 11th May.
Your Lordship has posted it.
11th May. Special weekly list item 37.
It is there for us, my lord. Your Lordship may kindly see the report of the Tahsildar is in seal cover is at flag X. Perhaps he has directly filed this case.
All right, the seal cover be opened, the report be made available to the parties for the counsel to the parties. List on 11th. All right.
Copy may be directed to the shop.
Item 37.
Lord, item 37, no instruction.
No
And
instruction.
virtual mode.
Post off. All right.
Special weekly list item 38.
Hello. Item number 38, Advocate Procurator and Associate, my lord, the R may be withdrawn. We delete.
Counsel to the
Maybe pardon my
PK
lord,
Ratha
the
and
interim order
Associates
is there.
says,
Your Lordship may kindly extend.
no need, sir, nothing will happen.
No, Your Lordship has extended.
If something happens, you file an IS. All right. Mr. PK Ratha.
38, I am appearing for the opposite party.
and
one and two,
company
my lord. We have
withdraws
already
their
taken action against
appearance.
the plant, which is under the challenge. Operation of the plant is under challenge. We have already taken action, pollution control board, my lord. We have already taken closure order.
And my lordship, I am for the OP number 5. The plant has already been closed, your lordship.
All right.
Pursuant to our direction.
Dismissal non-prosecution. All right.
Item 39. Special weekly list item 39.
I am for the opposite party number 2.
All right. None appears dismissal non-prosecution.
Item 40.
Item 40, I am for the petitioner, my lord. But I am given a date chart, my lord, and
we'll have it on some other day, sir.
Your lordship.
List on 17th May.
The interim order to continue.
All right. Interim order to continue.
Item 41.
Item 41, not pressed, my lord.
Dismissed is not pressed.
Name of Mr. Mahapatra may be reflected for CDM.
All right.
BDM, for BDM.
All right.
Special weekly list item 42.
None appears dismissal non-prosecution. And can't be. No point. See what happens. Mr. Katkia, what's the latest?
There is, in this case, item 42. There was my instruction today in the morning that the trial is in progress, but the exact status I have not received.
All right.
He wants some time to get the exact status.
Katkia states that the trial is in
All
progress.
active persons have surrendered.
And all accused persons have surrendered and the trial is in progress. No further directions are called for. The petition is disposed of.
Special weekly list item 43.
None appears dismissal non-prosecution.
Special weekly list item 44.
None appears dismissal non-prosecution.
Special weekly list item 45.
45 will receive the matter. The petitioner, this has been transferred from the single bench to this honorable court.
Sorry?
From single judge bench to this honorable court.
Okay.
It has been renumbered as PIL because the petitioner is a member of the educational agency below. That is, it was established of the Clause 2 College below and registered on the Societies Registration Act below. That was at Annexure 1.
What is your prayer, sir?
Prayer is that, Lord, the
there is
Annexure 3, Your Lordship,
Annexure
can
3.
page 18.
Yes, Lord. Annexure 3.
Constitution of District Level Coordination and Monitoring Committee. That is a 30th September 2011.
Yeah.
Annexure 3 may be seen, Lord. Annexure 1 and Annexure 3 may be seen, Lord. In
Sir,
that,
does the cause of action survive?
yes, Lord, that
How?
survives.
How does it survive, sir?
Annexure 3 is a fraudulently taken registration, Lord. Annexure 3.
You file a criminal case for that.
So that is that, my lord. On that ground, on that I have represented to the authorities.
No.
1, 2, 3.
For everything comes the representation, sir.
They have considered also. There is a inquiry going on. Inquiry is going on, and the inquiry
is going on for the last 10 years. This is a 2012 matter.
They have appointed one inquiring officer.
2012 matter, sir. We are in 2022.
Yes, they have the progress is not known to me. That must be known.
Then it's okay. You follow up the matter and file a fresh petition if cause of action survives. This is a matter filed in 2012.
It survives, Lord. The cause of action survives, Lord. Annexure 3 may be seen, 1 may be seen.
So you don't know what the position today is, and you keep saying it survives.
Yes, Lord, because it is a fraudulently taken. My signature was posed, Lord, in Annexure 3.
How is your signature means what? It's a private petition.
Yes, I preliminarily I have filed the petition as a member of the educational agency, Lord. In Clause 2 college, I was a member of the governing body, Lord. And that there I signed in the memorandum of association. And that is Annexure 1, Lord.
But it is
that my kind be seen.
This is not a
related market committee.
That is just
yeah, it is not a public interest litigation. Yeah, in the considered view of the court, after hearing the counsel of the petitioner, this petition cannot be treated as a public interest litigation since the petitioner is personally involved in it and is seeking reliefs for himself. Placed before the roster bench of the single judge on 9th May.
Special weekly list item 46.
Item 46, Lordship, I'm appearing on behalf of opposite party number 2.
None appears for the petitioner.
I am for the petition, my lord. I am permitted to submit on behalf of Mr. K.P. Mishra. I am for the petition, my lord. My lord, may I be permitted to submit, my lord?
What's the prayer? Let's see that. Seniority of assistant law officer.
Yes, my lord.
All right.
Yes, my lord.
What is the age of the petitioner, sir?
Petitioner age, my lord, 51, 59, 61, my lord.
Is he still serving?
He's retired in the mean. Lordship, we've received instructions that he is superannuated.
So what survives, sir?
What survives, my lord? My promotional, my seniority may be reckoned from the date.
All that you argue.
Yes, my lord. Lordship, kindly turn to page number 9.
All right.
I am in the merit list.
All right.
At serial number 1.
Right.
Sri Alok Ranjan Nayak, page number 9, my lord.
Right.
And my date of appointment is 1/7/91.
Right.
Page number 11, Lordship, kindly turn, wherein at page serial number 1, I am at the merit list at the top, but mistakenly it is reflected at 15/12/92. My date of appointment 1/7/91, and the Sanjay Kumar Pani date of appointment 15/7/91. Both were joined on ad hoc basis. And I am at the top of the merit list, and I am senior to Sanjay Kumar Pani in the date of entry into service on ad hoc basis. However, the OSHB, the opposite party, mistakenly considered my date of entry into service as 15/12/92 and date of entry into service of Sanjay Kumar Pani on 15/7/91. Although I am selected top of the merit list, my seniority is placed below Sanjay Kumar Pani. My detailed representation is at annexure 4, page number 60, wherein I have categorically stated my date of entry into public service, OSHV service is 1791.
So the answer is in para 5 of your counter affidavit.
Counter, I have not solved a copy, my lord. I'm aware
You
of
were
the
on ad hoc basis, the other man was appointed on regular basis.
Lordship, I'm for opposite party number 3. The opposite party number 2 has filed a counter.
Right.
A copy may be solved today and thereafter tomorrow, lordship can fix, I can make a submission, my lord, filing rejoinder in this.
So this counter was filed long back in 2014, sir.
No copy is solved, my lord.
Who's for these? Opposite party number 2?
I'm appearing on behalf of opposite party number.
Do you have proof of service of the counter on the other side? No.
No, Your Lordship, I'm not being able to find it.
You have a copy to serve on the other petitioner or you don't?
Yes, sir. Lordship, I'll serve copy.
All right. Copy of the counter affidavit filed by opposite party number 2 be served on the petitioner within 2 days. Rejoinder if any be filed the next day. List on 27 June.
Special weekly list item 47.
My lord, in this case, my small modification, my lord. That is a suit for partition. That is in the first appeal. My lordship also passed the order allowing to file a fresh suit before the learned court below. But in advent that it is also stated that that the first appellate court order is confirmed and the branch of Durgacharan as a appellate court, however, same is not binding on the legal heir of the Durgacharan. I am the branch of the Durgacharan, my lord, that I am entitled for to file a suit. But the such a reflection is which is confirmed. That is in it way that the learned court below will also influence. So that's
I
why
can't follow a single word of what you said just now. I'm going to ask Justice Rotary whether he understood. 1 minute.
my lord.
Neither of us have understood even single word of what
Yes,
you
my
said.
lord. I'm placing. My lord, is suit for partition against the decree and suit for partition where the defendant, appellant was the defendant in the trial court. My lord, it was decreed in the year 73, 27/9/1973. Thereafter, the plaintiff preferred appeal before this honorable court in the first appeal, my lord. First appeal number, my lord, 16 of 1974. It is the judgment was pronounced on 23/12/92. Against such a first appeal, my lord, I preferred the AHO. I am before my lordship and AHO disposed of, my lord, my lord, on, my lord, I am placing AHO disposed of on 7/8/19. In first appeal, while disposed of, the AHO disposed of, this honorable court also passed the order, my lord. I am in the latest part of the order, page 6 of the order, may kindly be permitted to place, my lord. Learned counsel appearing for the appellant as well as the respondent fairly submitted that the parties are agreed that possession of the parties to be respected. The legal heir of Durgacharan, my lord, the appellant branch of the parties, that is not agreed to settlement of the dispute, even though the plaintiff and the respondent have agreed to be parted with the part of the property for them. Considering the submission made by the learned counsel for the parties, and after going through the record and keeping in view the fact that the suit for partition is an old one, and there is no bar for filing fresh suit for the parties, the decree passed by the first appellate court is confirmed, my lord. And however, the same is not binding on the legal heir of Durgacharan. Then the appellant Durgacharan branch is before my lordship, Vikramaditya. So, but when I am allowed to file a fresh suit before the learned court below, that for agitate my grievance for suit for partition, that is it is also reflected that the first appellate court order is confirmed. So that's why in this is such an ambiguity. My lord, I am coming for the modification saying.
This can't be done by an IA, sir. Sorry.
My lord,
What is sought to be done in the present
only
IA is far beyond the scope of an application for modification or clarification. Consequently, this IA cannot be entertained in the present form. It is dismissed. Right.
Special weekly list item 48.
My lord, not this.
Yes.
Special weekly list item 48.
Disposed of case. None appears in this application. Dismissed. All these are applications. Don't put the main matter. These are all applications. You have to put the application number. None appears in this application. In the earlier one, we find no merit in the application. The application is dismissed. This again, application is dismissed.
Special weekly list item 49.
None appears for the applicant. The application is dismissed.
Special weekly list item 50.
Again, none appears for the applicant. The application
appeals the opposite party.
Opposite party. Okay, all right.
Special weekly list passover item 2.
Passed over for the day tomorrow. I shall do the case one because short note also it is
All right.
necessary for your
The list on.
tomorrow. I shall.
It's on 28th March. At the request of learned counsel for the applicant. All right.
Weekly daily item 1.
The demand is more than 2 crores, 2,56,000, right? Only one question is arises at page 5, at page 6, my lord. Whether on the facts and circumstances case, the tribunal is justified in allowing claim of depreciation and interest separately against the income of the SSC, although same has been estimated after consideration of all expenses, including depreciation. Two High Court judgment is cited in page 5. Allow the High Court in the case of Saria Engineering Works Limited versus CIT, while estimate income of the SSC, company claim of depreciation separately on vehicle cannot be allowed. And page 4 in.
No, they were simply following the earlier decision of the tribunal in the SSC's own case.
Yes,
so it has to be on consistent basis, sir.
Yeah.
What happened in that earlier year, 9-10? What happened in that?
It was below limit, so the case has been allowed. It is above 2 crores, so it is pending.
No. Past records are also there, sir. Just see para 2.3. Several AYs.
I said 9, 10, 10, 11.
No. Even para 2.3, not only 9, 10, 10, 11, 8, 9, 7, 8, everywhere.
Yes.
We say the present appeal by the department is directed against an order dated July 2014. Sorry, 15 July 2014, passed by the Income Tax Appellate Tribunal in ITA number 493/CTK/2013 for the assessment year bracket AY 2010-11. Paragraph. The question sought to be urged by the department is whether the ITAT was justified in allowing the claim of depreciation and interest separately against the income of the SSC, although it had been estimated after consideration of all expenses, including depreciation. Question mark. A perusal of the impugned order of the ITAT shows that a similar claim had been allowed for previous AYs involving the same SSC, including the AYs 5, 6, 7, 8, 9, 10, and 9, 10. Full stop. Consequently, following the rule of consistency, the ITAT was justified in allowing the claim for the AY in question as well. No substantial question of law arises. The appeal is dismissed.
Weekly list item 2.
None appears dismissed.
Weekly list item 3.
I am permitted to withdraw. Counsel the petitioner seeks leave to withdraw this petition. Dismisses withdrawn.
Weekly list item 4.
In item 4, the appellant has preferred for Vivad Se Vishwas scheme.
Therefore,
permitted to withdraw.
All right. Counsel for the appellant has opted for the Vivad Se Vishwas scheme He accordingly seeks leave to withdraw his appeals, disposed of his withdrawal.
Weekly list item 5.
My lord, item 5 not pressed.
Counsel, the petitioner states it's not pressed. It's disposed of as such.
Weekly list item 6. Weekly list item 6.
None appears dismissed from opposition.
Weekly list item 7.
That review petition.
Yes, please.
That review petition order has been passed by your lordship and lordship Justice Portman.
All right. List on. We'll have it 1 week later. List on 15th March. Right.
Weekly list item 8.
None appears.
I think this is similar. Justice Patnaik and your lordship has passed the order that is sought to be reviewed.
All right. List on actually CMAPL.
CMAPL.
List on 15th. All right.
Weekly list item 9.
May I please, Your Lordship? Your Lordship, though the matter is very trivial, but the petitioner is unfortunately forced to approach this honorable court for a small issue for which he is struggling since 2018. The matter is that, a simple matter is that in front there is a narrow road where hundreds of the people of the Army UTC center customers are parking
The
their
representation is there. You say the petitioner's representation dated 21st January 2022 should be considered by the Director Canteen Services, and after hearing the petitioner, the reasoned order should be passed thereon not later than 25th April 2022. And the order be communicated to the petitioner not later than 2nd May 2022. All right. The petition is disposed of.
Weekly list item 10.
Obliged.
My Lordship, this petition is in the form of a PIL which seeks to challenge the charging of fees by private schools, which has been enhanced for the academic year 2021 to 22. My Lordship, the reason for the challenge is the period during this academic year, there has been suspension of classroom teaching except for certain classes which had opened for a few months.
All right. Whatever you're paying will be subject to the outcome. You say notice. Who's you're accepting notice?
In fact, the council petitioners and the page minus annex 2 minus. There's already judgment by my lords. There's a very
no. This is over the recent increase. I think it's not the previous one.
Judgment is for 2020 to 21, which is annexed in.
Yes, but in fact, in the petition also it has been mentioned that some of the schools that did not mention which schools they are not given a list at all. It's in general. There's some of the schools, not all. So I don't know which
there was no clarity on what the schools followed. That should be there with the Department of School and Mass Education. My Lord, there was an MOU, and at the same time there was a government notification dated 3rd of June 2021. Some of the schools followed the MOU.
Anyway, you place all the details on record. Yes, you say Mr. Parida accepts notice for the respondent. Replies be filed within 4 weeks, rejoined with the next date. The fees paid by the students in the meanwhile will be subject to the outcome of the petition.
My Lordship, there's an interim application.
That's what it will be subject to the outcome, whatever you're paying.
If I may be allowed to press, my Lord, there have been instances where schools, when they opened on 28th of February, they have not allowed students to enter in.
So you pay and it will be subject to the outcome. So, list on 11 July.
Weekly list item 11.
Malad is posted to Malad?
11th July.
Obliged.
This is the second round of litigation that though the land belongs to some of the land is owned, but it is admitted by the opposite party collector when adjudicating the matter that it is a owned land, and the private opposite party who is a builder who has constructed a Paka house thereon, which is in clear violation of the rules and regulation, but no action has been taken by the opposite parties to evict him or to take appropriate action in accordance with law, because that plot it's some as on date, that is a pond tank. And the village peoples use that pond. And page 28, the collector opposite party number 22, those Srimati Raut is promoting pisciculture in two big ponds exist on the above land. A Pakka two-storied building has been constructed. But no action has been taken to evict him. This is the kisam of land of pond. You lordship, there are several Supreme Court judgment I have given.
So we'll come to the judgments in a minute. Let's try and understand the facts, sir. Come to para 5, page 28.
Yes. In the course of hearing on the representation and records thereof, it is revealed that the writ petitioner contention regarding illegal encroachment of the land in question by the OP number 6 of the writ petition is not substantiated by facts. Then I will substantiate it by facts. I have given the photograph.
Read on, sir. Kindly read on.
Carry on. Next sentence.
And it is revealed from the report of the Tahsildar Tangi Chaudhar that the land in question is enjoyed by the Chabirani Raut, OP number 6, by virtue of registered power of attorney bearing number so and so dated 12/10/2010 and registered cell deed number so and so dated so and so. Srimati Raut is promoting pisciculture farming on the suit land owned by her, upon which the nearby farmers are depending for their livelihood. Some construction of house have been made over the area of AC 0.12 decimil for resting of the farmers coming for that is completely wrong.
Kindly read on, sir. Make your submission later.
Right?
First read it and then you can make your submissions.
It is made clear that out of AC 6 acre 20 decimal of plot number 1307 Kisam Jalasraya, a major portion of 5 acre 62 decimal still exists as Jalasraya, which may serve the day-to-day activities of the nearby people. As such, it is reported that there is no habitation within half-kilometer radius of the alleged plot. Hence, the allegation that the locality are facing acute problems and deprived of using of funds for their day-to-day activities are not based on facts. In view of the above findings, the contentions are. So now I am coming to the point that opposite party number 6 is a builder. It is admitted fact by the inquiry authority, also by the opposite party number 6. And if she is a builder, she has purchased the land for the reselling of the plot and for construction of the houses. And the pisciculture, there is no symbol, no inquiry conducted. We have not been called upon. And we have given the photograph where you lordship kindly have a glance, three-storied building. Over 2 acres of land, he has filled up the tank. 2 acres of land she has already filled up, and page 22, kindly have a glance. There is already 3-storied, multi-storied and very big building is there. She has constructed. And now I have given that photograph. She has already filled up the ponds. And yes, on the pretext of only...
Let's ask. Mr. Mahanti. The photograph shows a nice full-fledged house. You have it. Page 22.
Yes, my lord.
Page 22.
Page
photograph. It's a big house there.
It is there, but what the collector has reported that
he says it's for resting of.
Yes,
doesn't seem to be such a small structure, sir.
I only want to submit 2 points before your lordship. First is it is the
resting
private,
of farmers.
Yes,
and for counseling purpose, it seems a full-fledged house.
Whether this building is within that area, that I cannot say. Because
so you find out. You find out. Mr. Mahanti, who has been served with an advance copy of the petition, states that he will seek instructions on the photographs at Annexure 1 series, and whether the building shown therein is actually on the land in question. At his request, list on. You better produce some photographs then. You can also list on 5th April.
status quo may be maintained because
We don't know, sir.
because
We don't know what.
she's fill
All
upping
these
the
orders
ponds.
are problematic.
My lord, she is fill upping the ponds.
Let's see. You are now saying she's constructing, she's
I
going
have
to.
constructed the rest part. She has filled up the ponds.
All
I have given the
My lord,
photograph.
may issue notice to the opposite party. No. That private opposite party may be.
Or it is say notice he access for 1, notice to 5 within returnable by the next date.
Your lordship,
Tracking report will be placed.
there is several judgment. Japal Singh that is categorically says pond
First
cannot be.
will allow them to file replies, then judge.
Your lordship may protect that status quo. Otherwise, she will completely fill up, and there will be no symbol of pond. She has already halfly fill up.
Fill up with what?
Fill up the mods to complete to not to show that it is not a pond land.
All right, let's see that. Let's see that.
Weekly list item 12.
Like it is a very delicate issue that PIL, that national highway going through that 4 districts, that Chaudhar and the Anugol, all these way. And even though the Gayatri Construction who has taken for the construction of the road, she has given the undertaking to complete it within the period of that by January 2022. But no development and no construction, further construction took place. In the meantime, more than 20 people died on the road. And there is huge dust and no more bus is running on that way because of this not completion of the road work. It is very serious and delicate issue, man.
Who's for the NHAI? Mr. Amitav Das. Why don't you serve a copy on Mr. Amitav Das? He appears for NHAI. An advance copy of this petition be served on Mr. Amitav Das, who appears for the NHAI, to enable him to seek instructions. You serve it on him today itself, sir.
Lordship has fixed it to
23rd March.
Weekly list item 13. Weekly list item 13.
None appears dismissed from not
Item 12.
or disposed of. None appears in this application, dismissed from non-prosecution.
Weekly list item 14.
So many defects still there. How come? So many defects not removed.
No, my lord, I 14 defects. I permit to remove.
What's the matter about you? Tell us.
Lord,
What's
matter is not the question is framed in page 5. Page 5, whether on the fact and circumstance of the case, the learning ITA justified in deleting the addition made by the assessing officer with 1 crore on account of unexplained cash credit under Section 68 of the Income Tax Act.
this tax limit is there for this?
Sorry?
The monetary tax limit.
Yes, my lord. It's more than, it's not 1 crore 79.
But the addition is only 1 crore.
1 crore is not that 1 crore. Other part, the department has not challenged other issues that has been allowed by the tribunal. And here the
No,
fact,
for this 1 crore, what is the tax effect?
1 crore is not. It is a 30% because it's
So it will be less than the monetary limit, sir.
But
Less than the monetary limit. Monetary limit is 50 lakhs, right?
no, 1 crore now. It's
1 crore. So it's obviously less than the monetary limit. The addition itself is 1 crore.
No, addition is 1 crore, but others points also there.
What is there?
Others is 43.
No, this is the only question that you've asked for, sir.
Yes, so far as department is concerned, yes, asked for the one question is for.
Then what else other questions should we look at? You see, the questions ought to be urged is regarding the addition of 1 crore, a deletion of 1 crore, which was added by the assessing officer under Section 68 of the Income Tax Act 1961. Clearly, the monetary limit of the tax effect is less than the permissible limit. You see that clearly the tax effect is less than the permissible monetary limit. The appeal is accordingly treated as withdrawn and disposed of as such.
The question are kept open for others.
Not necessary, sir. This is all on factual. 68 is all factual.
Absolutely.
Weekly list item 15.
May I please, Milords? I'm just taking notes from your lordship's brief, Milords, and I may be permitted to place that little
No,
note.
we'll have it on some other day then. Because it will take time. List on 17th, no, 18th May. All right.
May I just humbly pray that I may be permitted to take a copy from your lordship?
Sure.
Much obliged. 18th May.
Yeah.
Much obliged.
Weekly list item 16.
None, yes, hand appears for the applicant.
I'm from the.
Dismissal no application.
Weekly list item 17.
17 Milords, I'm appearing for the petitioner. The questions of law is at page 7.
Not admitted yet.
Not admitted yet. There's a miscase also for dispensing with filing of certified copies of annexures 1 and 2. They are not the impugned orders, they are the orders of assessment and the appeal order, my lords. Here the question is, my lord, what they have done is, they have relied on my 26 A's forms and they have said that this is the income which you derive from the transportation business, my lords. My humble contention, my lord, is that 26 A's is only a reflection of the TDS which is deducted on the gross receipts. And this, my lord, cannot be the basis for determination of my income, my lords. So in fact, that is my first question at page 7. If your lordship would kindly turn to page 7 of the brief, my lords. And the second question, my lord, is that they have resorted to addition of a profit of 5%, where I have said that, my lord, it's 2%, my lords. And that has been also noted by the
A and E.
Sorry, perhaps?
A and E.
A and E, my lords.
Right. So admit the following questions of law are framed for consideration. Take question 3A, which is page 7, and 3E, which is page 8.
There are two miscases also. One for dispensing with for filing certificate copies of 1 and 2. That is miscase 1.
All right. The other is
132 is
stay. What is a stay? There's no
stay, my lord, is this amount.
Nothing is what happens, sir. You say
I just
132, you just said allowed as prayed for.
133 let notice go.
All right, 133 notice. He accepts notice of admission of appeal as well as a stay.
If you lot.
List on 18 July.
18th
July.
18th July. No, so I have a humble prayer, my lord, for the subsequent year. There's another ITA 16 of 2017. If your lordship could call for that record, so. Or you're posted tomorrow.
Let it come in.
Weekly list item 18.
18, Lord, they have gone for the Vivad Se Vishwas Tak scheme. So it may be disposed.
The appellants have opted for the Vivad Se Vishwas scheme. The appeal is accordingly not pressed and is disposed of as such.
I'm appealing that because.
All right.
Much obliged, Lords.
Weekly list item 19.
Lordship, item number 19 on behalf of Mr. Divedi, I seek a week time, Lordship.
Defect is there, sir, still. 2017 matter.
Lordship will remove within this meeting. A week time will enter.
The appellant is in some difficulty. List on 5th July.
Weekly list item 20.
Please, your lordship. Lordship, this is
item 21.
Item 21 permitted to withdraw.
Counsel, the
It
petitioner
became
seeks leave to
instruction.
withdraw this petition with liberty to file a fresh petition if the cause of action suffices.
Weekly list item 22.
Lordship may be permitted to remove the defects. There are defects in the petition.
Be listed after removal of defects.
Weekly list item 23.
I may be permitted to remove the defect within 2 weeks, my lord.
Or list after removal of defects.
Weekly list item 24.
None appears dismissed, not prosecution.
Weekly list item 25.
May I please, your lord? My lord, the REIT application was dismissed on the 6th.
Which was the combination?
Combination is, I think, Justice Patnaik was.
Okay.
Yes, yes.
This next list on 16th March.
Weekly list item 26.
May I please, your lordship? I am in VC, my lord.
Yes.
My lord, your lordship order passed on 24th February 2022. Instead of opposite partner 2, inherently it has
This
been
order
cited-
has been passed sitting along with my Lord Justice Patnaik.
It's all right, sir. Only that opposite party number 2 has to be changed. That's all.
Yes, ma'am.
How,
Yes,
how
ma'am.
does that matter? We've said collector anyway. Anyway, all right. The order be modified by substituting opposite party number 3 with opposite party number 2. All right.
Yes, my lord. Yes, ma'am.
Weekly list item 27.
May I please, your lordship? Here the defect has been removed. My defect is service of copy. Here, my lord, the PIL is in respect of a Gochar land, there has been encroachment. A representation under Annexure 2 has been made, your lordship, at page 9, which is in Orissa. Admittedly, the land in question is a Gochar land. More than 2 months have elapsed. No action is being taken. May
All
I
right.
press?
The petitioner's representation be disposed of by who should dispose it of, sir? Collector.
By the Tahsildar, your lordship, he is
Or
the original.
Tahsildar Balyapal after issuing notice to the. But you have not named the encroachers.
Yes,
No, because they are number of my lord. They say huge.
But in fact,
Somebody you have to name, sir. You have to name somebody at least.
in the representation also, they have not been named.
You say council.
I'll place it for the Tahsildar, your lordship, may indicate that one.
All right. Is permitted to make a fresh representation to the Tahsildar, naming the encroachers. If the representation is made not later than 4th April 2022, shall be disposed of after hearing the petitioner and the alleged encroachers, and a reason order shall be passed thereon not later than 28th June and communicated to the parties not later than 27th June.
Obliged.
Weekly list item 28.
May I please, one. Item number 28, this file was with Honorable Justice Sri Mahapatra. Thereafter, I have sought instruction from the client. If your lordship permits, my lord, a week's time, I'll file rejoinder if possible.
My lord, this is a matter, my lord, asking for shop room inside the Andhra Bazaar Puri, my lord, and inside the temple, my lord. I am appearing for Lord Jagannath. By now, it must have been, it has changed, my lord. Now the situation is completely changed. It has become infructuous. This is 2006 matter, there is no stay order. So it has alert. There is no shop room inside the Andhra Bazaar.
My lord, in fact, there was an interim order passed in this writ petition.
He says there is no interim order. Let's just see. Yeah, status quo.
Yes, ma'am.
This is status quo. All right, at the request of counsel, the petitioner lists on 12th April.
Obliged, ma'am.
Weekly list item 29.
Interim order to continue.
Obviously, sir.
Item 29.
None appears dismissal numbers.
Weekly list item 30.
30, my lord, they challenge the declaration notification. I'm appearing for the National Highway Authority. They
All right, none appears to the petitioner, dismissal non-prosecution.
Yes.
Weekly list item 31.
Name may be indicated.
Yes.
Obliged.
None appears, dismissal non-prosecution.
Weekly list item 32.
None appears, dismissal non-prosecution.
Weekly list item 33.
May please your lordship. This is a PIL matter, my lord. Matter relates to protection, preservation and conservation of water bodies, my lord, in Cuttack city, my lord. Counter and the rejoinder has already been filed by the respective parties. This matter appears to be this as per the order number 14 dated 11 August 2021. On the said that this honorable court has directed to file the rejoinder on the affidavit filed by the opposite parties on 9/8/2021. In response to the said direction, petitioner has already filed the rejoinder, my lord, on 7/10/2021, my lord.
Is it there?
And the matter has already been covered. This issue has already been resolved by this honorable court by their judgment dated 11/10/2012, my lord. A copy of the said judgment has been enclosed as annexure 2, my lord. The relevant portion of the said judgment finds place at page 43, my lord, paragraph 14, my lord. I may be permitted to draw your lordship kind attention to the relevant portion of the said judgment, madam.
We don't have counter rejoinder, you have it? Is there? Is there a counter? Anyway, we can't hear it in this combination, sir. We're only sitting today.
My lord.
List on 27th April.
Obliged, my lord.
Quickly list item 34.
34 minutes, if I seek some time to inquiry only one issue. The tribunal
It's a
says-
covered matter, my lord. I am appealing
I'm
with my lord.
please, 2 minutes. Why you are so?
I am not saying anything. I am appealing.
But
I'm
I
saying I
only
am-
needs one instruction from the department because the earlier the tribunal has passed the order in favor of the revenue. I have
Sorry,
favor of the
because the-
SSC. In favor of the
Assess-
SSC, yes. That
So I
order
need
is
instruction
good.
whether these, what is the fate of that appeal, whether any order was in passed by this court, I have no instruction. Only I'm not 2 weeks time so that I'll take it. If not, it is against us, then Lord, I have no case.
I'm not able to follow what
Your
you're trying to
Lordship,
say.
page 35.
May I explain?
Tribunal said that identical issue are raised by the assessee own case before the tribunal attend so and so assessment 89, 90 and
Yes,
91.
they will know. They are here, very much here. They will know whether it's
No,
been
Lord, I have
filed or
to, he may say, Lord, I have to take instruction on this
Whereas
issue. Only
I have got the orders of the
Ah.
tribunal.
Tribunal, I am saying whether they
I am-
challenge before High Court or not, that has to ascertain.
Appeal was not filed and the tribunal has recorded in page 35, the lordship will kindly see the order of the tribunal, para 22.
Yes, that is what I am facing. Sir, that is what I am facing. I need one time.
Yes,
I am not running
yes.
away from. If it is not there, then I don't have any case. That's why let's say we should give 2 weeks time. I have already informed the.
you revive this appeal if an appeal has been filed. I permit you to revive the appeal if an appeal has been filed.
Yes.
Quickly list
Well,
item
this has been-
35.
1 minute, sir, 1 minute.
Yes, the payment to a subsidiary, whether it is allowable as a business expenditure not under section 37 of the Income Tax Act.
Here he is a separate entity. He has expense for separate entity, separate company. And the issue which I have instructed my telephone, the fact of the issue is slightly different. Therefore, I am seeking time. Otherwise, Lord, I never ask for time. Only 2 weeks time, Lord, nothing will happen. Lord, you will be, if Lord, I am failed, Lord, you will in the case. Nothing will happen. Lord. And the question of
Lord,
law is already
that
admitted.
8990 and 1991, same issue was there before the tribunal. There also, I added my subsidiary, that is East Coast Breweries, and that written off was challenged by me before the tribunal. And the tribunal, in that case, I have got the orders of the tribunal. Lordship may kindly see page 8, paragraph 18. Paragraph 18 of the tribunal's order, there the learned income tax appellate, Lordship may kindly turn to para 18 of that order, that the objective is to aid and assist any industrial undertaking and the subsidiaries. Brief resume of the subsidiary company and the reason for giving the loans and advance and also the reason for writing off is given in page number so and
Let
so.
him take time, sir. Let him take.
Yes.
Counsel for the revenue seeks time for instructions regarding appeals filed against the orders involving the same SSC.
Yes, same SSC. Yes.
For the earlier assessment years. At his request, list on 20th April 20.
Man.
This is 34, 35, 36.
All are same. All the question of law has been admitted by the Supreme Court.
Up to 39.
39. No, sir.
39.
Up to 39.
35 to 39.
Quickly list item 40.
May I please, ma'am?
Today I am filing the latest instruction obtained from the registry, and the request of the petitioner has been accepted and she has been allowed
Yes.
to join Balan.
You say the petitioner's request has been accepted by the registry Nothing survives and the petition is disposed of. All right.
My lord, I have a humble apology, my lord. That as sitting in before video conferencing in CDS sector 11, my lord, because of interest, my lord, I could not attend the matter. So immediately I rushed to the this honorable court, where I find the matter 8 is already been called for. My item is my lord, item 6.
Item 6.
Yes.
What do you want to say in 6?
Now, item 6 is that it's a
Item
case
6
of
is Magma Foods Private Limited.
yes, my lord. And in this case, I am for the petitioner. Now, the government has levied some excess water tax 6 times of what should be put on. So, in that concern, my lord, there are areas as stated by the opposite party. The arrears pertaining to 12 lakh rupees has been imposed on me, whereas regularly I have been paying the monthly rents till to date. And today, my lord, I am filing the up-to-date rental receipts till today. Only matter is for consideration is whether the extra groundwater which the opposite party claims on me. So that is the subject matter of dispute, my lord. So my humble submission is this: I am just today filing, my lord's up-to-date ground water rent up to year 2022 January.
14952.
One matter maybe
Of 2021, counsel the petitioner seeks and grant permission to file additional documents over the next date.
In fact, all these are factual disputes. Under Rule 58 of the Odisha irrigation rules, revision is to be preferred before the Board of Revenue or the RDC.
Why didn't you file the revision petition, sir?
My lord, the appellate authority I have filed before Honorable Collector, and he has rejected my appeal. But without being notice being issued to me, they have imposed the extra taxes and with
Why didn't you
cumulative
file a
interest.
revision? He says a revision petition is maintainable. You say counsel the petitioner seeks leave to withdraw this petition. Item 6, 14952 of 2021. Counsel for the petitioner seeks leave to withdraw this petition at liberty to file a revision petition under
Rule 58 of the Odisha irrigation rules 1961.
Rule 58 of the Orissa Irrigation Rules 1961. This post office withdrawn with liberty is paid.
My lord's permission. My lord, item 33. I'm sorry, my lords, I could not connect. I just connected immediately after that matter. PIL matter, my lord.
It's adjourned, sir. 27th April.
Oh, bless.
All right.